Yes.
Trying to, my lord, bring it to your lordship's notice, my lord. I have filed an application in connection with a writ petition, my lord. May the application be taken up, my lord. There is some urgency in the matter. My lord, what is the urgency, my lord? By an order, your lordship desired that the proceedings continue. This is that.
No, but then whatever is the
My
urgency,
lord, the urgency is, my lord, the inquiry officer.
whatever is the urgency, did you mention the matter on the day when the mentionings were
Yes,
accepted?
yes. My lord, your lordship desired that since the proceedings has not been directed to be completed without leave of court, I am not allowing it at the present. The difficulty is, my lord, the inquiry officer, whoever he has been appointed in terms of your lordships, my lord, they inform the inquiry officer.
No, I do not want to know the merits. Was the application mentioned
Yes,
on
yes.
the day
On the day, my lord, when the mentioning
was
first
allowed?
Monday.
Yes, then it will appear in the list.
My lord, may it not have some precedence on the 25th. My lord, your lordship has
it.
desired 25th applications will be taken up after motions. That is the indication.
Every Thursday I'm doing it.
I know. My lord, I mean, may it appear, my lord, on the 25th. My lord, there is some urgency. My lord, I'll be
Who is your
completely
other side?
non-suited.
Who
My
is
lord,
your
the
other
inquiry
side?
officer,
Who is your other side?
my lord, Mr. Ashim Kumar Raut. I have served a notice on him. Upon notice, I am mentioned.
All right, give the number. দেখুন তো এটা অ্যাপ্লিকেশন আসার কথা ছিল, আসেনি কেন? Yes.
May I permitted to move one urgent matter? My lord, urgency is that
Move one urgent matter.
my lord, paid leave to move an urgent matter, my lord.
What is the urgency?
My lord, the petitioner was a government employee under a hospital, my lord, and he want to pursue, my lord, MD course, my lord. Accordingly, my lord, he admitted in a college, and thereafter, my lord, no NOC is not given, and my lord, period of my lord academic session is 2024 to 2027. My lord, we are in 2026. If the NOC is not provided, my lord, then the petitioner could not complete his degree.
Obviously, from 24 the cause of action
my lord.
started.
But
why are you coming in the mid of
petitioner
26?
petitioner initially applied for trainee reserve. My lord, that is not provided. Day after day, they the authority said they we will provide. My lord, petitioner made several representation. Even then, my lord, the petitioner.
No, file it in the department.
My lord, kindly, my lord,
in the department. Yes.
To mention one contempt application, my lord. My lord directed me to serve upon the contemnants, my lord. We found the matter is returnable on 2nd of July. My lord, we found out that the incumbents has already been changed, my lord. My lord, kindly give us some, kindly make it to be mentioned tomorrow so that your lordship, please
Give the number. The file has to be brought. Keep an eye on the list.
Yes, sir.
Inclusion of an application, my lord.
Today is not the date for inclusions. Release. Why?
my lord, this is a group 2 matter, but it's topic filed on group 6. My lord, filing date is 9/8/2024.
24.
My lord.
And it has come to your notice in 26. After nearly 2 years.
My lord, the matter is not in the list, my lord.
May not be in the list.
My lord,
What suddenly cropped up that you got to know that it will be a group 2 matter and not a group 6 matter? For 2 years, nothing happened. Give the number. দেখুন তো to be mentioned রাখা যায় কিনা?
My lord, may I permitted, my lord, one contempt application, my lord. It was appearing in the.
Why are you mentioning for what purpose?
My lord, for upgradation, my lord.
Sorry,
my lord,
today is
petitioner
not the date.
getting, my lord, pension, my lord.
Correction. What happened?
Petitioner applied, my lord, feasibility.
Ah,
There, my lord, mention self-medicate.
give.
My lord, pension is not getting, my lord. My lord, contempt is appearing, my lord.
Yes.
For correction.
What is the correction?
Correction is the disease
Obey, my
for
lord, application.
legal certificates, but there is no teaching the legal.
What is mentioned?
Mention that the release the matter in further consideration for 14th July 2026.
Yes.
Nothing's legal in this regarding the legal certificate.
It will be relisted. The matter is not disposed of.
Well,
What is
I
it?
have challenged the charge sheet, my lord. I mentioned this matter on 8th, my lord. Your lordship asked me to, my lord, come back again after some time. My lord, on 18th, my lord, they have, my lord, proceeded with the disciplinary proceeding.
Hmm.
My lord, that is the urgency, my lord. Otherwise, the reputation will become infructuous. My lord, the charge sheet is absolutely frivolous.
Where is the matter?
Ballot item number 317 along with 380. Two matters are there.
317, 318.
318. And they will proceed with the disciplinary proceedings.
Thursday দিয়ে দিন তো
And-
to be mentioned day. Intimate your other side.
I will.
My lord, urgent determination of Justice Mitra, my lord. My lord, in the previous round of litigation, my lord, there was an order staying this order of suspension till 22nd of June.
Listen, it is only for a day,
Yes, my lord,
please-
I will be suspended from today itself. In
So-
order was till yesterday, my lord.
right?
Now, my lord, they did not complete the proceeding. Now, my lord, automatically I'll again be suspended.
I
My lord,
don't,
kindly seize the order.
at second give you leave, it will appear before the regular bench
Lord, I
tomorrow.
will not, there will be a break in service. This honorable court, my lord.
I am not going to interfere today. Your other side will not be here.
I'll serve, my lord. I'll serve, my lord.
Nevertheless, it's better you come.
My lord will give
take
me
leave.
leave to move tomorrow, my lord.
Yes, leave tomorrow before the regular bench.
My lord, may I mention?
Extreme compelling circumstances, but in one disciplinary proceeding of the LICI matter, where Lordship has my lord, directed the LICI to issue any final order after my lord placing it before your Lordship, then only. So, my lord, yesterday, my lord, they have issued an order for termination without my lord intimating or praying for a leave from this honorable court. So, my lord, I have taken out an application yesterday only. So, my lord, I know, my lord, the matter may be taken up on Thursday when your Lordship takes it up. My lord, I just beseech your Lordship if my lord, some precedence can be granted.
Give leave and
numbers I have
intimate
given.
your other side.
Yes, absolutely. my lord. Grateful. my lord.
May I-
Yes,
Yes, my lord, I want to mention two matters, my lord. One, writ petition against a transfer order whereby I will be relieved on 30th of June, my lord.
yes.
And another, my lord, there was a termination order which I challenged before the writ court. And my lord, in the termination order, there was a notice period. Writ court, considering that the order is in complete violation to natural justice, stayed the termination order. The moment the writ court stayed the termination order, they passed an order saying that in the termination order, there was a notice period. We will not allow you to work continuously.
In the termination matter, is the writ petition pending?
Writ petition pending, my lord. That's why I have filed a CAN application, my lord.
All right,
There is
pass
a
on the
stay.
number.
My
When
lord,
is
my
the
lord,
bench sitting? When is the bench sitting over there?
Bench 29th, my lord.
29. That means Monday.
My lord, the difficulty is that the notice period I am working up to 30th. And that's why the writ court given them 1 week time so that before that it can be disposed of. But they have thrown me out of, despite of an order of interim order of the court saying that the termination is illegal.
I understand because, but then think
My
it
lord,
over
let it be
because
taken tomorrow, my lord. I request, my lord, I will serve and come back, my lord. Because,
pass on the number.
yes, my lord, I am passing the number.
Port Blair scan copy নিয়ে আসতে হবে সব আনিয়ে নেবেন কিন্তু all the list please.
But I am for the Indian Red Cross Society. My lord. On the last occasion, Lordship may kindly refer to the last order. There was a date fixed for the discussion regarding the
Yes.
amicable settlement. So far, the petitioner's claim is concerned, my lord. We have settled. We have prepared the check. They can collect it. My lord, one point cropped up, my lord. That was regarding the vacating of one of the quarter belongs to the Red Cross Society's property. That was also my instruction, is my lord. Obviously, my instruction. They says that they will hand it over.
When?
That they have not said anything. Now they are saying that they have not.
Nothing
It's a
has
part
been
of the
discussed in
discussion.
this matter. On instruction, nothing has been discussed. They asked me simply the bank account and authorization.
That is your money, it is all right, but how can you hold on to the property of the Red Cross Society?
By the erstwhile owner to us.
How?
Yes, allow me to stay there. There is a different premises. And they have filed a suit against me also. That suit also
Well,
dismissed.
there is a deed I have shown, my lord.
That-
However,
Red
we
Cross
are,
Society filed a suit.
no, no, no.
Yes, yes.
We have not. It's a their interstate suit, maybe.
No.
We are
In
not.
Aliyah, Sialda court, they have filed a suit.
Who has filed?
By Indian Red Cross Society?
No.
Give the number.
I'm giving the
বুঝেছিস? Suit file করেছে? Sure.
2015, after vacating of the 10 by 1 premises.
Well,
This is a
Let me see.
ছিল
Indian Red Cross Society.
Hmm?
4/2 Kedarnath Banerjee
No,
Road.
no, they are asking for order against the 10/1.
10/1 is not in dispute.
Yes,
Dispute is 4/2.
That is the C, that is the pursuit. They are asking for vacating out of 10/1.
ঠিক আছে but kindly give us liberty to initiate the appropriate
One
proceedings.
minute.
No, it is-
Specifically, the previous can be to-
Can you do that or-
Right now, the issue is 4/2 and not 10/1.
Yes.
What about 10/1? Under which provision of law are you holding 4/2?
4/2, I got it from the erstwhile owner who has sold out to the Indian Red Cross Society.
You got it means how you got it?
They allow me to stay there.
Allow you to stay?
Yes.
When? How?
77, 78.
The deed that was shown on the last
Yes, sir.
occasion, what is the... This is of no consequence. For 10/1 is not the issue over here.
Whether this was submitted, this deed is in respect of
4/2 Kedarnath Banerjee Road Lane.
to Kedarnath Banerjee. Page number 9, Lordship will get the schedule.
এটা ফেরত দিয়ে দিন, ফেরত দিয়ে দিন।
Being premises number,
I
Date,
occupied
date.
premises. They should
Whether-
file a suit against the 4/2. They have not filed it.
but 1978, my lord.
1978.
Can you see?
Is there from 1978.
Prior to that, 10/1, they has filed a suit for eviction.
10/1 is not the subject matter of this writ petition.
দেখুন স্যার 4/2 কেদারনাথ Banerjee.
Yes, I know, but we are staying in a 4/2 prior to their possession, execution of the deed.
And Lordship kindly come to the cause title address given there.
Yes, it's 4/2.
4/2.
Yes.
That Kedarnath
We are-
Banerjee.
That is admitted.
And this is also the,
We are admitting. We are admitting we are staying in a 4/2.
and the property belongs to Red Cross Society.
Then if he is in forceful occupation, you have to take steps for...
Yes, my lord. Kindly observe that. And my lord, I beseech your lordship to consider one aspect. Since the position of law is very clear that there cannot be the to Article 226 application be maintained against the Red Cross Society. There are the judgments of Gujarat High Court and other high courts also into that effect, my lord. So kindly do not treat this matter as a precedent, my lord. Kindly, that will open a floodgate maybe.
Please come. It has been submitted by the learned advocate representing both the parties that amicable settlement has been entered into by and between the parties in the hearing held on 15th June 2026. Stop. The due of the petitioners will be paid. Stop. It will be open for the petitioners to go and collect the check from the office of the Red Cross Society. Stop. As regards vacating the premises number 4/2, Kedarnath Banerjee Lane, which the petitioners are allegedly holding without any authority of law, it will be open for the Red Cross Society to take steps in accordance with law for getting the same vacated.
My lord, may I only draw your lordship's attention to one document which we have given it with our opposition, my lord. It was a letter dated 28/9/2013 issued by one Pankaj Kumar Mukherjee, the father of the petitioner. My lord, where he said that it may also be intimated that after obtaining full retirement benefits, I am ready to vacate the quarter within December 2013. This was an undertaking given, my lord. It's a part of the record.
দেখি
Opposition.
opposition আছে তো এটা কেন?
It's part of the opposition, my lord.
10/1 বলেছে? Possibly that is one of the 10/1. And they have deducted entire gratuity amount as a penal rate. My lord, they have deducted entire gratuity amount from the penal rate. And my lord, kindly consider this a provident fund is a non-attachable asset. How can we attach this? Then my money is also involved in this. From their own document, they have deducted. Entire, they have not paid any gratuity.
এটা না অপোজিশনটা দিন, এটা তো এক্সেপশন।
Written instruction on behalf of respondent number 1
Yes.
and 2, my lord.
Yes, page number
It's a page number 28, my lord.
28. Which address it does not mention.
It was not me.
Nowhere mentioned. Nowhere they have mentioned. On last occasion, Lordship also observed it.
Each petition stands disposed.
My lord, it shall not create any precedent, my lord.
I have not mentioned anything and nothing has been decided only because you all have settled it out of court, so it is gone. So no order as such.
Grateful.
Well, kindly only one word, kindly asset. I am disputing this is a non-attachable asset. This is a provident fund.
No, nothing of
My
this.
money is also involved. I have
Yeah,
deposited the money.
I have to get back my property also, Red Cross property as
Call the next one.
over.
See,
Grateful, my lord.
I have also deposited the money.
My application for review, there is a delay of more than 300 days.
300?
Yes, Milord, I tell you, Lordship, why? Milord, I preferred an appeal.
My lord, before he tells your lordship's why, my lord, I would like to use an affidavit to
SEBI.
the application.
Against the SEBI.
Yes, ma'am. I would like to use an affidavit.
To the delay condonation?
Yes.
Milord, my learned senior friend taught me that Milord not to oppose delay condonation application.
My lord, and what to do, my lord? Supreme Court has now given 2 judgments. So the principle of condonation of delay is no more a judicial generosity. I'm sure he's realized it by now.
Milord, it was because of the submissions made, Milord, on behalf of SEBI that, Milord, the review was preferred.
Yes, of course. And that, my lord, that was in January 2026.
Correct.
Your lordship dismissed the writ, appeal from there.
Milord,
In
I
the
thought
appeal,
it
they
was-
say that we would like to file a review.
I thought it was my application. Milord, if I'm hijacked, Milord, that's different.
Acha. Please come. An application for review has been filed. Challenging the order.
March 27th,
2025.
27th March 2025.
Passed by this bench on 27th of March 2025. Stop. The review has been filed at a delayed point of time. Stop. The respondent seeks time to file opposition to the application for review. Is there a separate section 5 application?
Yes, Milord, there is. IAGA 1 is, Milord, the delay condonation.
To the application filed seeking condonation of delay
Yes.
in filing the application for review. ঠিক আছে? Let affidavit in opposition be prepared and circulated within a period of 4 weeks. Reply, if any, within a fortnight thereafter. List after completion of the aforesaid time period.
Milord, may I prefer one indulgence? Milord, if Milord, there be also directions for Milord exchange of affidavits on the review application. If I lose Milord in my delay
No, my lord,
condonation,
kindly don't do that, my lord. That may not be the
Milord,
appropriate procedure.
otherwise, Milord, this will get delayed. If
Yeah,
Milord kindly
sorry.
passes directions for
You
exchange
are
of
already delayed.
Great.
That's-
Why all on a sudden you want to jump upon the court and the respondents?
But I'm not jumping up on the court. Milord, there was
Next.
some grateful people.
My lord, may I first hand over the list of dates which we have prepared?
List of this.
Others. No, others side. Other side. My lord, I am not relying upon the list of dates because we have already stated the facts which have been incorporated in the list of dates. My lord, I
You only want to cite certain judgments
my
possibly.
lord, judgments I will cite and also the relevant rules.
Rules.
Yes, ma'am. Rules. Sir, rules in the copy. এটা আপনার রিজার্ভ ব্যাংকে
রেলিভেন্ট পোর্শন অ্যানেক্স করা
অ্যানেক্স করা আছে আমরা জাস্ট না না ওইটাই ওটা প্রিন্ট আউট নেই হ্যাঁ my lord first this my lord I'm relying upon the rules pertaining to the leave of Reserve Bank of India. It starts from page 35 under chapter 6, my lord. My lord, there are as many as 9 kinds of leave. My lord has already is aware of the fact that the petitioner was granted ordinary leave, sick leave, and extraordinary leave. My lord will find that at regulation 75, clauses B, C, and D. My lord, page 35. I'm sorry. Now, my lord, kindly skip over to the very next page, page 37. My lord, clause 84, regulation 84, leave may not be granted to an employee under suspension or against whom proceedings are pending under chapter 4 of these regulations. My lord may remember at the time when this leave was granted, first leave when he applied, when the first he was transferred at that relevant point of time in 2008, there was a disciplinary proceeding was pending against him, which was also challenged before the High Court by filing a writ petition WP 61 and 62. Now, my lord, kindly take note of page 38. Page 40. My lord, 91 1 rule regulation 91 1. My lord, it pertains to the my lord sick leave. Page 40, my lord, my lord will find last but one paragraph. My lord, may I just read this portion? During the full period of her service, an employee may be granted special leave on private affairs for a period not exceeding 12 months. I'm not concerned, my lord. And sick leave on medical certificate for a period not exceeding 18 months. The central board may grant additional sick leave if considered admissible in the bank interest in special cases. So, my lord, on medical certificate, the individual is entitled to a total period of 18 months of sick leave in his entire service tenure. Now, my lord, lastly, 94, regulation 94.1, page 42. This is extraordinary leave. My lord, may I just read? Extraordinary leave may be granted to an employee when no ordinary leave is due to him, her, and when having regard to her length of service, sick or special leave is not considered justified by the competent authority. My lord, kindly mark this word. Sick or special leave is not considered justified by the competent authority. Except in exceptional circumstances, the duration of extraordinary leave shall not exceed such as 3 months on any occasion and 12 months during the entire period of an employee's service. My lord may recollect that for the period for which we have granted the special leave, extraordinary leave, my lord, there was no leave application. Nothing was there.
Yes.
We granted ordinary leave and sick leave for those periods for which leave application was there, not for those periods for which there was no application. This order which was passed or this communication was made to the petitioner in the year 2010. Petitioner was aware of it. He did not challenge. In 2022, he cannot come and say that there were other leaves available at that relevant point of time. The authorities has discriminated or the authorities has acted wrongly by not granting him the other leaves. Now, my lord, the question will may arise that whether this exercise of the petitioner is defeated by delay and laches or not. My lord, in this regard, I will rely upon certain judicial pronouncements, my lord. My lord, finally, first take note of 2009. My lord, I'm sorry. This has been marked by me the relevant sir. I mean, sorry, 2009 volume 1. আমি সেটাই চেষ্টা করছি ভলিউম 1 this is 168 I'm sorry, my lord, it is being, my lord, kindly directly take note of paragraph 26 and 27. My lord, I'm for the convenience, my lord, I'm be allowed to read those paragraphs. May I read? And 27. My lord, this is a fresh copy. Should I hand over?
No, it's all right.
It is well settled and needs no restatement at our hands that under Article 226 of the Constitution, the jurisdiction of a High Court to issue appropriate writs, particularly a writ of mandamus, is highly discretionary. The relief cannot be claimed as of right. One of the grounds for refusing relief is that the person approaching the High Court is guilty of unexplained delay and the laches. Inordinate delay in moving the court for a writ is an adequate ground for refusing a writ. The principle is that the courts exercising public law jurisdiction do not encourage agitation of stale claims and exhuming matters where the rights of third parties may have accrued in the interregnum. Stop. 27. The appellate in its reply opposing the admission of a writ petition in clear and categorical terms period in the writ petition has kept silent for more than 35 years and has filed a belated writ petition. It was asserted that on account of irradiated delay and laches in the writ petition suffers from legal infirmities and therefore liable to be rejected in nihilo. The High Court did not record any finding whatsoever and ignored such a plea of far-reaching consequences. Para 30 also, what will be the duty? It is reiterated, my lord, but still, my lord, I am reading that para 30, what will be the duty of High Court under Article 226? The High Court, while exercising its jurisdiction under Article 226, is duty bound to consider whether adjudication of a writ petition involves any complex or disputed question of facts and whether they can be satisfactorily resolved. The petition relevance all material facts. The petitioner has any alternative or effective remedy for the resolution of the dispute. Person invoking the jurisdiction is guilty of unexplained delay and laches. Exposé is barred by any laws of limitation. Grant of relief is against public policy or barred by any valid law and host of other factors. My lord, in this case, my lord, we have tried to showcase through our opposition as well as the pleadings in the writ petition that there was not a single evidence or single averments in the writ petition from the year 2000 explaining what is the ground which prevented the petitioner from re-agitating this grievance after his retirement in the year 2013. 2013 till 2022, the petitioner retired in the year 2013. Till 2022, the petitioner, after accepting all the benefits, retirement, post-retirement, pre-retirement benefits, kept silent, completely silent of the issue. Now, one fine morning in the year 2022, he made a representation which was duly replied to. Otherwise, it had been the case of the petitioner that the respondent have not replied to the representations. Now, my lord, kindly take note of the এটাও লাগবে 2019 স্যার আমি এটা my lord this was also in respect of delay, but this was the issue was on the compassionate appointment. My lord, kindly directly take note of paragraph 35. My lord, may I just read?
Yes.
Insofar as the individual facts pertaining to the respondent are concerned, it has emerged from the record that the writ petition before the High Court was instituted on 11/5/2015. The application for compassion.
Paragraph 35, you say?
Yes, madam. Paragraph 30. My lord, have I?
Krishna Mission?
My lord?
Is it Ramakrishna Mission matter?
No, 2019 volume 3, my lord.
No, it's volume 16.
I'm sorry. I'm sorry. Yeah, yes. I'm sorry. Last date bar.
Yes.
My lord, 35. My lord, we'll find that at page.
Yes, I got
70.
it. Hmm.
Insofar, my lord, merit. Insofar as the individual facts pertaining to the respondents are concerned, it has emerged from the record that the repetition before the High Court was instituted on 11/5/2015. The application for compassionate appointment and was submitted on 8/5/2007. On 15/1/2008, the additional secretary has required that the amount realized by way of pension be included in the income statement of the family. The respondent waited thereafter for a period in excess of 7 years to move a petition under Article 226 of the Constitution. In Umesh Kumar Nagpal, this court has emphasized that the basis of scheme of compassionate appointment lies in the need of providing immediate assistance to the family of the deceased employee. The sense of immediacy is evidently lost by the delay on the part of the dependent in seeking compassionate appointment. Thereafter, the similar position has been relied upon, my lord, in paragraph 37 also. My lord, we see no reasons or purpose in now deciding the state to reconsider its decision in the case of the respondent, which would only result in another round of fruitless litigation. In our view, the respondent is debarred from seeking compassionate appointment by the delay as well as by the lapse of time which has taken place. My lord, now another aspect of the issue, whether the petitioner is estoppel by his conduct now to seek the remedy which otherwise he is seeking. My lord, I do not have a copy. My lord, I am reading from a book. My lord, at the moment I do not have a copy. My lord, I undertake to supply a copy of the relevant extracts, my lord, at the time of, if I am permitted to file any written notes. Sir, এখান থেকে আমি দিয়ে দেবো পরে। আমি পরে দেখতে। My lord, may I just read? It is on the issue of representation by act and conduct. My lord, I am reading from Spencer, Bauer and Tunnell, Estoppel by Representation, 3rd edition. The second class of representations comprises those which are implied from the acts and or conduct of the representator. In the given case, the representator is the petitioner. Almost unknown before the 19th century, this class of estoppel has so rapidly increased in bulk and importance that it may now be said, without exaggeration, that most of the cases of estoppel by representation during the last 100 years and more have been this type. Since at least the year 1837, words and conduct have been continuously asserted in judicial exposition as two separate forms in which equal rights, with equal effect as an estoppel, a representation may be made. My lord, the second topic is burden of proving representation. The onus is on the representative, that is us in this case, of establishing the precise acts and conduct alleged and further of showing the acts and conduct so proved were of such an unequivocal character as to involve the particular representation relied upon as the ground of estoppel. In all the cases in which on which this burden has been discharged, it has been held that there was a representation capable of operating as an estoppel. Many illustrations will hereafter be collected of such estoppel by conduct in the chapter which is concerned with the application of the principle of estoppel by representation to various transactions 3 classified. My lord, in the instant case, why I am saying that estoppel by conduct, I am again for the sake of repetition. My lord, to 31st July 2013, the petitioner retired. Thereafter, the petitioner was released in favor of his all the benefits which he was entitled to. The petitioner accepted all those benefits. We were under the impression that whatever he was supposed to get, we have given that, because the petitioner did not raise any objection at the time of receipt of those benefits. Therefore, in 2024, the petitioner cannot come, is stopped by his conduct to raise the issue which has since attained finality.
Yes.
My lord, this is also, my lord, this conduct of petitioner may also be akin to estoppel by silence, because he was silent all along. And in this regard, my lord, the book reads, my lord, may I just read once? Representation by silence or inaction. It is well established that under certain conditions, silence or inaction may constitute a representation as much as positive language or conduct for the purpose of an estoppel. The main condition subject to which alone silence or inaction counts as representation is that a legal, not a mere moral or social duty shall have been owed by the representative to the representative to make the disclosure or take these steps, the omission of which is relied upon as creating the estoppel. So it was not only our duty to ensure that the petitioner receives all benefit, it was also the duty of the petitioner to confirm that the benefit which he has received is not correct or not proper. But the petitioner did not do so. As a consequence, by applying the principle of estoppel by silence, I say that now this writ petitioner cannot be entertained. My lord, lastly, my lord, there is one judgment on delay and laches. My lord, this was reported in AIR 1964-1006. My lord, and for the sake of educational purpose, I have relying this judgment, my lord. The very first which AIR 1964 SC 106. My the relevant portion here also. Sir, a copy. Sir, AIR 1006 00. My lord, it reads, my lord, I'm reading from paragraph 15 on. We see, my lord, may I read?
Yes.
It starts from, my lord, internal page 8. We see no reason to think that the high courts have not got this power. If a right has been infringed, whether a fundamental or a statutory right, and the aggrieved party comes to the court for enforcement of the right, it will not be giving complete relief if the court merely declares the existence of such right or the fact that the existing right has been infringed. Where there has been only a threat to infringe the right or an order commanding the government or other statutory authorities not to take the action contemplated would be sufficient. It has been held by this court that where there has been a threat only and the right has not actually infringed, an application under Article 226 would lie and the courts would necessarily give reliefs by making an order in the nature of injunction. It was hardly be reasonable to say that while the court will grant relief by such command in the nature of an order of injunction where the invasion of a right has been merely threatened, the court must still refuse. Where the right has been actually invaded, to give the consequential relief and the content itself is merely a declaration that the right exists as has been invaded or with merely quashing the illegal order made. Para 16, for the reasons given above, we are clearly of the opinion that the High Courts have power for the purpose of enforcement of fundamental rights and statutory rights to give consequential relief by ordering repayment of money realized by the without the authority law. My lord, in this case, with all my subject to correction, the petitioner has failed to prove the what fundamental right has been infringed, which will compel this honorable court after such an inordinate delay to allow the writ petition. Well, there was no case made out by the petitioner wherefrom it will be apparent, yes, there was an infringement of the fundamental right on the part of the respondents, or there has been an infringement of any statutory right which otherwise the petitioner was entitled to. Well, para 17. At the same time, we cannot lose sight of the fact that the special remedy provided in Article 226 is not intended to supersede completely the modes of obtaining relief by an action in a civil court or to deny defenses legitimately open in such action. It has been made clear more than once that power to give relief under Article 226 is a discretionary power. Well, it has been repeated. This is especially true in the case of power to issue writ in the nature of mandamus. My lord, the other has again, my lord, what we have read that has been quoted. What is the power of under Article 226? My lord, lastly, the judgment which the petitioner relied upon.
This you don't want to rely, Ramakrishna Mission?
My lord, can I have a copy of it?
Yes, please. It's your copy only. এটা দিয়ে দিন তো।
No, man.
Keep it with you.
হ্যাঁ উড়িষ্যাটা একবার দেখি খুঁজে পাচ্ছি না মানে lastly the petitioner relied upon a judgment reported in 1972 SCC online Orissa 105. My lord, fact with subject to correction, my lord, rule 5 which the petitioner para 5, my lord, there was a specific clause to that effect, that extraordinary leave may be granted in special circumstances where no other kinds of leave is admissible, where any other kind of leave being admissible, the government servant concerned applies in writing for the grant of extraordinary leave. Well, the factual aspect, I humbly submit the factual aspect of this writ petition and the factual aspect of this judgment which the relied over are completely different and hence has no manner of applicability. Because we have already shown that there was no leave application for that period. And he did not challenge that. And কে government servant? এও government servant, ও government servant. দুজনেই government servant. My lord.
Over. All right. Your reply.
Would you permit me tomorrow?
Tomorrow it won't be possible.
Then your losses. I have little difficulty on Monday and Tuesday. Friday is holiday.
Friday is a holiday.
So your losses take it up on Wednesday.
All right, please come. A learned counsel representing the respondents concludes argument. Stop.
वो हम नहीं rely कर रहा है.
Learned senior counsel representing the petitioner intends to revert with the reply on 24th. Stop list on 24th.
I'm grateful, man.
The 24th one next. Oh, first. 24. It will be Wednesday.
1st July.
Yes.
Your ladyship, if your ladyship is not taking up the next matter today, then can it be taken up next Wednesday?
I appear for the petitioner, my lord. This is regarding that regularization.
Yes.
What happened? Anything happened?
I have written again, I'm in talks, but no concrete.
Then what is the use of adjourning?
No, my lord, tomorrow and day after I will not be there. That's why.
No, but then it is taken that there will be no amicable settlement and the court has to proceed.
No, they have not said no yet.
They
I
have
have
not said yes also, and it's
yes,
right
no.
for some time. How long will the matter be adjourned?
My lord keeps it on 1st of July next week.
All right, on the prayer of the learned advocate representing the respondents, release the matter on 1st July.
My lord. If nothing concrete comes, we'll do that.
Are you expecting something to come?
I don't know. The central government, sometimes officers change and then again the whole rigmarole starts again. In fact, yesterday also I had.
Officers, the same thing happens. Always. They come and go.
Yes.
But then maintain records to show that at least
Even yesterday I sent another mail.
it is from your side only. Is there anything from their side giving any indication that there is a chance of,
In fact, I spoke
there is
to
a possibility of
I
a settlement?
spoke to my friend. They appeared some possibility, but then he said that somebody has also said no to it. I don't have any official knowledge of that, my lord. Anyway, 1st July.
Get hold of some senior officer who can take a decision. If you go
Even here, the senior most officer here, he also shows complete.
The only difficulty, my lord, is the vigilance. Why have you taken?
Now the departmental officers here, they are all pro the petitioners. Even the
even then, no concrete decision is taken.
no
Positive.
That's the problem, my lord.
Very well, let us see.
I'm obliged.
Well, in this matter, your lordship on the last occasion called for the written instruction from the department PSS. Well, I am yet to receive the instruction. Well, kindly keep it at 2 p.m., my lord.
2 o'clock.
2 o'clock.
Today they will come.
I hope so, my lord. I hope so. The concerned person talked to me personally. They are trying to get it
at 2 o'clock.
By 2 o'clock.
All right. 2 o'clock.
This is that assigned matter. Your lordship probably is in online. But till date, no formal application as per the law has been filed. And so far, if your lordship kindly see the order passed on 22nd of May and on 9th of June. On a repeated occasion here, this court was pleased to direct them to apply in a prescribed form. What they have done, they have made an application, give me a transfer on an online without any supporting document. And this is the precarious situation we are facing in spite of the order.
Petitioner, are you there? Item 2.
Your Lord, may I pray for a note today, Your Lordship? The petitioner is seriously ill. Your Lordship, we have to file the application exception by tomorrow, Your Lordship. The exception is ready, Your Lordship, but the petitioner could not went to the court. And Your Lordship, by tomorrow we will affirming the exception, Your Lordship, and tomorrow
How
we
can
will
you
file.
affirm by tomorrow if your if the petitioner is ill today?
Your
Take
Lordship,
some
she
more
has
time.
been ill, Your Lordship, but by tomorrow she could go to the court, Your Lordship, and by tomorrow we will do the affirmation. That's why I'm praying for a not today, Your
I
Lordship.
fail to understand in the
Then in that case, we have to serve a copy upon your learned friend.
Your Lordship, by tomorrow I will do the same, Your Lordship.
Then the matter
By
cannot
tomorrow.
be taken up tomorrow. Please come.
Your Lordship, kindly keep it at second half, or Your Lordship on Thursday, Your Lordship.
Learned advocate representing the petitioner seeks extension of time for filing the
No, Your Lordship, I'm not seeking extension, Your Lordship. Exception is ready only for the affirmation, Your Lordship. Only tomorrow the affirmation may be done.
On such prayer, time to file the
And
exception
Your Lordship, I
stands
pray for
extended till
reconnection, Your Lordship.
25th, day after tomorrow.
Grateful, Your Lordship.
Let a copy of the same be handed over to the learned advocate representing the respondents. Stop.
Obliged.
Release the matter for further consideration on 29th of June.
I'm deeply obliged, Lordship.
Your Lordship.
What can be
After
done? We are
tomorrow,
trying
Your
to
Lordship.
resolve it. But this is the third time they are seeking time.
Why are you not making the application in the prescribed format?
Your Lordship, I have already applied, Your Lordship, with all the documents. Because
In
I
the
went to the
prescribed
office and they
format?
have- Yes,
In
Your
the
Lordship.
prescribed format?
They have refused the application, Your Lordship. Then I have applied online
Online. What can be done?
with their portal, Your Lordship.
Ma, we
They
are
make
ready and willing. They should be, they are welcome to the office with all the documents in a
3.
prescribed form. They are
Item
not
3.
coming.
3.
Time for the
Petitioner.
But
Who's for this state?
Madam Lordship, I'm sorry to interrupt. But in the last occasion, in the exception, your Lordship was pleased to direct that with the transfer application, they should file. But probably it has not gone in this order, probably. Thank you, sir.
But in this matter, I am
The
upon the benefit.
application made by the petitioner seeking transfer of the meter shall be annexed with the exception to be filed by the petitioner.
I'm deeply obliged.
this is my affidavit of service, my lord.
Yeah, item number 3, madam, I am date means upon the benefit.
State.
State, madam, yes.
Lord, private respondent.
You are appearing?
Respondent, my lord. Respondent 9, my lord.
Wakalatnama filed?
My lord filed already received and filed, my lord. Lordship, it is a matter of Asha or me, Lordship. Yesterday, my lord had
Yes.
said maybe a matter relating to appointment of Asha.
Group 5, I release it.
It is last occasion, my lord Justice Lobita Banerjee taken up the matter while he was under.
Taking up group 6 matters. But then that was possibly not drawn to the notice of the court. Please come, the matter relates to appointment of Asha. Stuff. The same has to be adjudicated in the group 5 determination. Stuff. Let
But
the writ petition be released from the list of this bench and be placed before the bench having determination to take up group 5 matters. Within bracket Panchayat.
My lord.
Panchayat.
My lord Justice Subra Ghosh is taken up. My lord, there is no whispering that Asha matter will be taken up there.
There is no
Mentioning of the determination, my lord, is not there.
it is not mentioned.
Yes, please say.
अच्छा, ठीक है, within bracket Panchayat. Learned advocate representing the respondents shall come ready with necessary instruction on the adjourned date. Service is taken on record.
Make correction on the
Leave granted to the advocate on record of the petitioner to make necessary correction in the presentation form and the front sheet of the writ petition.
Every service to pay. Service to pay.
Service is on record. Yes, for?
I don't know. Well, I picked up on the respondent, my lord. No, this is the matter where the bank disciplinary action was initiated by the bank against one of his employees regarding the bifurcation of the sundry assets and advancing loans. Subsequently, an appeal was preferred, which was dismissed, and a review was preferred. Thereafter, this petition was filed. In fact, a FIR has also been initiated. A quashing application
By
was
the bank?
by the accused person, by the employee. Quashing application was preferred by the employee against FIR was preferred by the bank. FIR was preferred by the bank. Subsequently, it was came up for quashing, and I gather the matter is still pending. Two things have to be considered, my lord, whether after the review petition, the writ application, it's a appealable order or not. First point of the story. Second,
appealable
means it's a writ petition will lie against the review petition or not.
Yes, why not? Every day we are taking up.
My lord, another is that we have asked for an instructions regarding the question of the FIR because of the standard of proof is very much necessary regarding the statements which has been given by the employees of the bank, the defense witnesses and others. But kindly comes to the review, the order of the review that comes at page 287. It is a two-paged order.
Yes.
It was categorically mentioned out here that
yes.
Coming from the last page. During the RBI of our SME branch, Durgapur, for review period, so irregularities, deficiencies observed in the different areas of the branch, particularly internal control and investigation, followed by the inquiry in the manner established that huge amounts debited to Sandra.
Where are you reading from?
My lord, it's from the 5th paragraph
Of page
of
two?
page number 287.
Yes.
My lord, got it? During
Yes.
During the RBI of our SME branch, Durgapur, of the review period from so irregularities, deficiencies was observed in the different areas of the branch, particularly internal control and investigation, followed by the inquiry in the manner established under huge amounts so that the said branch. The reasons to be debit sundry assets were not specific clear. In many cases, proper narrations were not written and the slips were not prepared properly. Branch was debited rupees 80,553 to sundry assets, others without any details on this date, and credited to the loan account maintained at Shiliguri branch, and the SA outstanding was cleared by depositing a cash on so-and-so date. It was observed that the cash receipt of rupees 50,000 above has been credited to SA employees TA LFC advance, being recovery of TA LFC advance drawn by the staff, violation by the norms of the bank. It has been further established that the petitioner has sanctioned various loans to the customers without obtaining the required loan papers, and loans were closed within a short period by transferring the amount from fresh loans sanctioned by the customers. Cash withdrawals were permitted by the checks without signatures of the drawers, without beneficiaries signing on the reverse of the check acknowledging the receipt of the payments. Loan amounts were credited by way of cash transfer. However, the credit slips were not available to the branch. Loan proceedings was transferred to the SB accounts, and the referred account opening from the KYC documents are not available with the branch. Loans were granted at the SME branch, Durgapur, and the loan proceeds were credited, transferred to 3 loan accounts maintained at Shiliguri branch, 1 account of Ashtepur branch, West Bengal. Thereby, the end use of these loans were not ensured. And so this entire things has been done in this manner. Two things have to be considered. In the review petition also, they have got an ample chance of hearing. I gather, in fact, filing of the review petition, the protocol has to be maintained to file an application. Thereafter, the review to be filed. That application is not there in this petition. And most importantly, they have stated in their petition that the witnesses, they have got a fair chance of hearing was not given. The affidavits were not placed properly. That is to be also taken into consideration.
What is to be taken into consideration?
Well, it has also been taken into, everything has been done as per the protocol of the bank. So it's not the case that the witnesses.
So it is your case that there has not been any procedural lapses.
Yes, my lord. That is my case. No procedural lapses.
Yes.
Only point which is a point which is now clouded with me only, my lord, that is whether against this review, my lord, it is a process that has already been, evidence has been taken by the bank, the appeal has been done, and the review is also there. Now, whether this concept of writ coming before this bank is there or not, that is clouded. The concept of coming to the writ petition, filing the writ petition before this honorable court is maintainable or not. That is clouded with me with this fact. But it may happen, my lord. I may be 100% wrong.
If there is a cloud, it is for you to clear it.
Clear it. Well, that is the reason, my lord. Let me give cases on Friday. If not, my lord, I'll be harping on the merits.
Then this Friday, though, there is no red marking in the calendar. It possibly will be a holiday.
Oh, declared.
It has been declared.
Huh?
Oh,
26th holiday. Oh, acha. But keeps it on Monday.
learned advocate representing the bank seeks time to come prepared. Released on 29th.
Obliged, my lord.
Lordship, I am for the respondent matter.
Respondent?
Respondents.
All
Yes.
respondents. Union of India.
Now, the point in this matter is very short. The petitioner, on due examination, was found that he was having 9.6 centimeter on height.
Not 9, 169.5.
169.5. Something 9 is hovering on my head. Now, there is a provision that if it is 0.5, then it should go to...
1 minute. The procedure of rounding off has been accepted. What is there to
No.
argue in this matter?
It has not been accepted. That's the point.
2024
They ought to
examination,
have-
Your Lordship.
It doesn't matter 2024. I approached the court on right time.
It was filed
Rounding
in
off
January
benefit-
2025. After the examination, like selections were declared. It was declared in 13 December
Does the
2020.
medical guidelines prescribe rounding off?
Now, yes, kindly that's page 25.
Then what is to, because rounding off, it has not been
Now-
accepted, you say?
Yes, it was not implemented in my case. That's my grievance.
No, but then the court is accepting it.
Court is accepting it. On the basis thereof, they should get my examination done afresh. And if I come on the merit, I will be considered. After the physical measurement, there are certain other procedures. I was knocked out at the stage of physical measurement. And if I succeed that I am entitled to get through physical measurement, the subsequent examination would be taken.
It's in the stage of the
It's
physical
not going to,
standard
it's
test.
not going to, let them file an affidavit showing that there is somebody rights is going to be adversely affected because of this. Illegalities once found in case of employment has to be taken care
Sir,
of.
please wait. Yes, madam.
Your Lordship, here is in the physical standard test also. This examination was done in 2024. Thereafter, the results were declared. Everything was completed in 13th of December 2024. And he had filed in January 2025, Your Lordship.
Not everything was completed.
So you say that there is delay in filing the writ petition. You do not contest the matter on merits.
Your Lordship, here the rounding off which is there, that is being considered. But this
Considered
is
by whom?
Your Lordship, division bench.
It has already been upheld. Rounding off.
Yes, Your Lordship.
Are you contesting on merits or on technical ground of delay?
On technical grounds of delay.
Is anybody leading you?
Miss Priyanka Tibrewal.
Where is she?
She's not unable to come today, Your Lordship.
2024 examination. We are in 2026. How long will the matter remain pending?
We'll file a report, Your Lordship.
That will delay the matter further. What will you disclose in your report? What is to be disclosed?
What is the present status, Your Lordship? In the 2024 was carried off to 2025, Your Lordship.
2024 recruitment process is long over. The court is aware of it.
Yes, Your Lordship.
Now what will be your submission?
These have been carried off to 2025, Your Lordship.
Court is aware of it. Now what will be your submission? Please come. The petitioner participated in the recruitment process of CAPFs in the year 2024. Stop. He stood disqualified in the physical standard test. On account of deficiency in height. Stop. His height was recorded as 169.5 centimeters. Stop. Paragraph. Learned senior counsel representing the petitioner submits that as per the medical guidelines, the principle of rounding off is to be ought to be considered by the authority. So the
Clause 2D, my lord.
The medical guidelines prescribe that while measuring height, fraction of 0.5 centimeter will be ignored and rounded off to the next higher centimeter. Step. In the instant case, the height of the petitioner was recorded as 169.5 centimeter. And if the principle of rounding off is allowed, the petitioner's height will be 170 centimeters, which is the minimum height required for qualifying in the physical standard test. Stop. Paragraph. Prayer has been made to direct the respondents to apply the principle of rounding off and treat the petitioner as eligible in the physical standard test. Stop. Learned advocate representing the respondent submits that the recruitment process for the year 2024 is long over. Stop. The petitioner has approached the court at a delayed point of time by filing writ petition in January 2025. Stop. Paragraph. Upon hearing the submission made on behalf of both the parties and on perusal of the documents annexed to the writ petition, it appears that indeed the petitioner participated in the recruitment process for the year 2024 and was found disqualified on account of deficiency in height at the physical standard test stage. Stop. The respondents inadvertently and erroneously did not apply the principle of rounding off as prescribed in the medical guidelines. Stop. Had the principle of rounding off been applied, then the petitioner would have been treated qualified as he would have secured 170 centimeters. Now, as his height would have been recorded as 170 centimeters. Stop. It is for the error on the part of the respondents that the petitioner could not proceed to the next level. Stop. Paragraph. The submission of the petitioner that the petitioner respondent that the writ petition has been filed at a delayed point of time cannot be accepted in the facts and circumstances of the present case, as the illegality on the part of the respondents in not applying the principle of rounding off is apparent from records. Stop. Next, in view of the above, the instant writ petition stands allowed. Stop. The respondents are directed to treat the height of the petitioner as 170 centimeters. Stop. Further necessary consequential steps shall be taken by the respondent authorities for
DME and DV next process.
For further steps shall be taken by the respondents in connection with the recruitment of the petitioner in the post of constable in CAPF without any further delay. Disposed. Next.
Grateful to your lordship. Deeply.
My lord, here my candidature has been rejected on the ground of shortfall of height.
Same.
No,
But
your
not
lordship.
same.
Not
It
same. What is
different.
the
My lord, here, my lord,
569.
only I have a weapon, that is a certificate given by a doctor who measured me 171 centimeter. It has been reduced 169 centimeter. That is all of my allegation. My lord, may I pray for one thing, my lord, what is fallen from your lordship, I know. Your lordship's mind. My lord, can it be directed to the respondent to reconsider?
No, it cannot be. The division bench's order is against you.
My lord, I have not preferred any appeal also.
Maybe.
That's why. my lord,
Harumia is against you. Had you been 169.5,
No,
I
that
would have allowed.
that is not.
If it is less,
2
then it cannot.
centimeter they have reduced.
What can be done? Please come. The petitioner participated for recruitment in CAPF stuff. He has been found deficient in height. Stuff. The measurement recorded by the authority is 169 centimeters. Stuff. To qualify in the examination, the candidate has to be 170 centimeters. Stuff. The petitioner failed to paragraph, as the petitioner failed to measure the required height. Accordingly, the prayer of the petitioner for directing the respondents for remeasurement cannot be allowed. Stop. It has been laid down by the Honorable Division Bench of this court that the measurements recorded on the date of the examination is relevant. Stop. Measurement taken on a different date is hardly of any consequence. Stop. Next, in view of the above, no relief can be granted to the petitioner in the instant case. Stop. The writ petition fails and is hereby dismissed. Next.
Oblige, Your Lordship.
Lord, I appeal for the respondents.
My Lord, I am for the petitioner.
Lord, item number 7, I am appealing on behalf of private respondent.
Did you file the wakalatnama?
My Lord, I received the wakalatnama, not yet filed. My Lord, I am undertaking, my Lord, the course of the day, I will file.
What is the matter?
My Lord, actually matter is that before his starting, my Lord, may I submit one thing? No copy of writ petition has yet been served upon me, my Lord. But I have managed one copy of writ petition.
How can you manage? Where from did you manage? Huh?
From the office, madam.
From the office of the respondents?
Ma'am.
No, but then direction was given for service. How is it that the writ petition has not been served?
My Lord, on last occasion you have directed and I have served, my Lord. That is not in affidavit. Actually, their address is something
wrong,
my Lord.
Anyway, now you've got it.
But
you've got the writ petition.
My Lord, I have.
Are you prepared today? You want to come prepared on another day?
My Lord, one thing, my Lord, on 9th March 2026, my Lord, a report was called for by my Lord. And a copy of report was filed, my Lord, on from the website copy I find, my Lord, on 20th April 2024. My Lord, if I get a copy of report, it will be...
Certainly, it will be given to you.
In that event, my Lord, kindly direct the authority, my Lord, to serve a copy of report, my Lord, and fixed on tomorrow, I'll ready. I'll be there.
Please come. Learned advocate representing the private respondent undertakes to file wakalatnama in the department in the course of the day. Stop. Copy of the report by the respondents be served upon the learned advocate representing the private respondent. Release the matter for further consideration on 29th June, Monday. You prepare an affidavit of service.
Yes, my Lord.
Report of the respondent, that is the only one report that has to be served. That is the only report which I have filed before the court. Whatever.
Good.
My Lord, Mr. Devajyoti Basu is arriving petitioner for here. He's arriving. Mr. Devajyoti Basu, senior advocate, appearing on behalf of the petitioner.
Yes.
He's on the way.
You start. Let him come.
Sure.
Will the matter be taken up here or not? This was the issue, isn't it?
Yes. Whether it should be treated as a service matter or not.
Wait, will it be treated as a service matter or a residuary? The other is residuary or what?
Subject to correction, my impression is that it should be a residuary matter.
Residuary.
Similar issue in respect of the Calcutta, 2-dock system, Haldia dock, Calcutta dock. Similar issue in residuary, that matter was filed. আপনাকে ছিল না দিন ওটা দিন residuary. Same issue, Malad, in respect of the safety security dock.
Residuary bench.
Lord, I appeal for the petition.
2021, it's to disposed of by the bench taking up residuary matter. So let it go before the residuary bench.
My Lord, this matter can be heard before this auction. But
No, you go. Please come.
no, my Lord, I have considered. My Lord, kindly, my Lord, take a look.
It has been submitted by the learned advocate representing the respondents that the matter relates to residuary determination. Stop. It has been submitted.
Lordship, my Lord,
The residual matter
heard me. This relates to service conditions. Our writ rules prescribe that Group 6 would deal with the service condition.
Registration number, হয় বলুন তো? দুটোই 19-এর 15,000
Second page last. Second
15632/2019 পার্টির নাম প্রবীর কুমার ঢালি and others versus Kolkata Port Trust and others.
My lord, may I address?
কি বললাম? Such and such was heard and disposed of by the bench taking up residuary matters
That
on
was on a
7th
different
April
matter, my lord.
2021.
I do not stand in that way.
ঠিক আছে?
Well, it might have been
In
it is
view of
filed
the
in group
above,
9.
let the
All
matter
relates to
stand
service
released
condition.
from the list of this bench and be placed before the bench taking up residuary matters. Stop. আচ্ছা উপর দিকে লিখে দিন তো একটুখানি। According to the petitioner, the matter is to be taken up by the bench taking up service
Well,
matters.
because I say
ঠিক
it
আছে?
all relates to my lord service conditions.
As
And our writ rules, my lord, prescribe.
a similar matter was disposed of by the residuary bench, let the matter be placed before the residuary bench. Next.
Admitted to. Thank you.
Uh-huh.
9 I am for the petition.
হ্যাঁ? This report আছে? ডিসমিস আছে এখানে তো লিখেছে ফর অর্ডারস আসার জন্য, তো ডিসমিস কোথায় দেখাচ্ছে? তো রিপোর্ট নয়। What is the matter?
In this matter, I am claiming appointment of a dependent of a workman who become permanently disabled in the course of his duties. As per the provision of NCWA. This is the second round of litigation, and everything has been decided in the first round of litigation. They have taken up the point of legal point as well as the factual point that I am not permanently disabled. They have placed.
You are not permanently
Yes,
disabled.
they have placed medical report.
If you are not permanently disabled, are you still working?
I have to take instruction because this is going on from 2021.
May I? 1 minute. Yes.
This is going on from 2021. So they have placed
This writ petition was filed in 2025.
because
What was the challenge?
the challenge is the resent order passed by them.
Show me the resent order.
This is the very last annexure. And starting from page 91.
Yes.
If your lordship kindly comes to page 92.
Yes.
At the middle portion, paragraph 6. They have quoted rule 6.5.0 and 6.5.2 that relates to grant of special leave to employees suffering from such and such disease. These are all temporary disablement. And 9.4.0, 9.4.0 they have quoted from NCWA 10. In NCWA 10, it is stated that a committee is constituted under the chairmanship of director, consisting of representatives of trade unions and management to finalize the scheme for employment. The aforesaid committee shall submit the scheme tentatively by such and such till the status quo shall be maintained. The original provision is contained in NCWA 6, and thereafter in each and every NCWA, this clause is maintained. The status quo will be maintained. And in page 93 also, they have quoted NCWA 11, and it's the same provision 6.5.2 and 9.4.0. And thereafter, if your lordship kindly comes to page 94, paragraph 11, it is there, my lord, reasoning. Sri Lakahari has sustained with 50% of his emoluments as per clause 6.5.2 of NCWA 10. That is to the tune of 45,000 on average till 2021 primarily, which was revised from time to time and thereafter until 28 to 2024 when he was declared as permanently disabled by the Honorable High Court at Calcutta. Still at present, he is drawing special leave allowance to the tune of rupees 50,000 per month without rendering any service. Sri Robin Hari may apply for employment commensurate with his qualification as and when the employment notification is published. And thereafter, they have rejected my prayer on the ground that they are paying me.
1 minute. Writ petition is filed by Lakahari.
Yes.
And another means is Robin Hari or party
Yes.
also.
Yes.
Did you apply for compassionate appointment?
Yes, my lord.
You applied. Hence, pursuant to the Honorable Division High Court and proper Lakahari's application for grant of service and by voluntary retirement cannot be considered in light of the measure of facts, shall continue to be granted special leave as may revised until such time is entitled to. All right, you are already getting your special leave allowance.
Yes, Manoj, that is my contention is, and that this honorable court has held in the first round of litigation, the 6.5.2 is not the applicable provision. The only provision that is applicable to Manoj permanently disabled employee is that of 9.4.0, that is Manoj to giving an employment to the workman, dependent of a workman. That is the only provision. There is no other provision, and Manoj, if your lordship kindly sees the Manoj
9.2. 9.1.2.
9.4.0.
4.0. The committee is to be constituted.
Yes, Manoj, that is the
And the committee shall submit a scheme tentatively by such and such till then status quo be maintained.
Manoj,
Right.
Manoj,
Has any scheme been formulated?
this is committee, Manoj. NCWA 6, Manoj, contains the original provision. Thereafter, Manoj, in each and every NCWA, because each
That means the scheme has not yet been formulated.
Yes, but Manoj, status quo to be maintained. That is why Manoj,
Status quo to be maintained means your father is already getting his salary,
no, Manoj,
wages. Then what is to be done?
status quo is to be maintained in respect of 9.4.0. That is the Manoj, the original provision contained in NCWA 6 shall be continued.
What does that say?
Yes, Manoj, 9.4.0, Manoj.
9.4.0 means the committee is to be constituted and a scheme shall be.
Yes, that is in NCWA 10. The original provision contained in NCWA 6, that is I handed over to your lordship.
This one?
Yes, Manoj.
9.4. Yes.
Employment to one dependent of a worker who is permanently disabled in his place. Thereafter, 9.4.0.1, the disablement of the worker concerned should arise from injury or disease, be of a permanent nature, resulting into loss of employment, and should be so certified.
Resulting in loss of employment.
Wait. Yes.
So, Manoj, and thereafter, in case of disablement arising out of general physical disability, this is Manoj general physical disability. I am covered by one as well because the permanent nature. And this court declares that. And Manoj, they have Manoj admitted in their recent order, Manoj, they have already said after declaration of permanent disability by this honorable court. They have admitted that I am permanently disabled. So, Manoj, this is the provision. And now, Manoj, kindly comes to the Manoj, what have been held by this honorable court. And what Manoj, legal points they have taken and factual points they have taken before this honorable court in the first round of litigation. Page 23.
Yes.
Page 23 of the petition, if your lordship kindly comes to the Manoj, in the middle portion of the order, it says ECL. ECL, the employer in such a situation is paying the petitioner 50% of the salary. The petitioner says that under the National Coal Wage Agreement, in a situation to which the petitioner is presently in, one of the family members of the petitioner is entitled to get an employment in ECL. Though the petitioner had requested to give employment to his son, the petitioner number 2, nothing has yet been done from the side of the ECL. Thereafter, Manoj, ECL has been directed to take specific instruction on these 3 things. Plus, they have thereafter submitted their report. And that is at page 27.
Yes.
Page 28 of your, if your lordship kindly comes.
Yes.
The very first, paragraph 2, the issue that has been answered is Roman 1. What are the formalities needed to be done by the petitioner for considering his son for employment in terms of the provision of National Coal Wage Agreement? That the petitioner has applied for voluntary retirement under clause 9.4.0 of NCWA, which has made available to the employees for seeking compassionate appointment of one of their dependents based on the ground of being medically unfit. Thereafter, by letter dated such and such of general manager, it has been stated that the implementation instructions such and such regarding clause number such and such, the same stands withdrawn with immediate effect. Hence, as per the prevailing agreements and relevant rules, the petitioner number 1 is not entitled to seek compassionate appointment of his son, since he has become medically unfit and is receiving 50% of his salary.
So it is no 9.4 is no longer there.
Yes, Manu, that is their contention is. And if your lordship now kindly comes to page number 30.
Page number 30.
Yes.
Yes.
They have quoted 6.5.2 and it is
Right.
their
Then
it is their contention that as per section 5.6.5.2 I am getting 50%, so I am not entitled to that. So now Manoj, what have been held by this court? Kindly comes to Manoj thereafter. Manoj, page 41 is the next order. If your lordship kindly comes to page 43. They have contended that this provision is withdrawn. The last portion of this Malad order, page 43. It is well settled that NCWA has the statutory flavors and is construed as an award under Industrial Dispute Act 1947. NCWA is formulated after a long deliberation between the employer and employees represented by registered trade unions, with the participations of the order other government agencies. To withdraw a clause in NCWA, proper procedure has to be followed. The letter dated such and such on the basis whereof ECL says that the benefit under clause 9.4.0 has been withdrawn does not reflect as to whether the clause 9.4.0 in respect whereof status quo was directed to be maintained in NCWA has been withdrawn following the proper procedure. In the aforesaid facts and circumstances, ECL is directed to file a further report in the form of affidavit stating in details the steps taken by the committee considered for finalizing the scheme as indicated in chapter 9 of 10th NCWA. The report shall also disclose such and such. This has been the direction of this honorable court to them, and thereafter, they have filed another report. And the relevant order, if your lordship takes page 56. This is after they have filed the report. Clause 9.4.0 of the National Coal Wage Agreement provides for employment to one dependent of a workman who is permanently disabled. In the instant case, the petitioner number 1 has claimed to have become permanently disabled. A previous medical examination of the petitioner number 1 had been conducted by ECL, pursuant to which the petitioner number is now being paid 50% of his wages. The petitioner have approached ECL with prayer to give appointment to petitioner number 2, being the son and the dependent of the petitioner number 1, for having become permanently disabled and unable to work. After considering the reports filed by the ECL and the submission made on behalf of the petitioner, it is explicit that the provisions for employment to the dependent of a medically unfit person has remained unchanged. And thereafter 57, a committee was formed and was directed to finalize the scheme by 31st March 2018. I am given to understand that the scheme has not yet been finalized by the committee. However, since NCWA presently in force provides for maintaining status quo till the time the scheme is finalized, the petitioner number 1 remains to be covered by the scheme as existing on date. The applicable rules of NCWA permit appointment to a dependent of a disabled employee. In the aforesaid facts and circumstances, the petitioner number 1 is required to be re-examined as to his physical illness and whether he is required to be declared permanently disabled for the benefit under clause 9.4.0 of the NCWA. So, Malas, their legal point that they have taken, Malas, has been set aside. And Malas, that is only the factual point, that whether I am permanently disabled or not.
Then what happened?
Malas, they have conducted a medical examination by their medical board, and the Malas submitted a report which is at page 63. And Malas, they stated that I am not permanently disabled, I am only temporarily disabled, and I can apply for a different job, alternate job. And thereafter, Malas, we have a filed exception to that report, and thereafter, this honorable court directed independent medical
This
examination.
63 is of 2022.
Yes, Malas. And thereafter,
Did
Malas,
you continue with the treatment?
yes, Malas.
Speech rehabilitation, physiotherapy, and continuation of the treatment.
Malas,
The
it was
patient
their
may apply
contention
for-
that they are providing me treatment for that, and that is why, Malas, I am not permanently disabled. It was their contention. And thereafter, Malas, this honorable court and directed Malas independent medical examination by Durgapur Subdivisional Hospital. That is at Malas page 71.
Yes.
That is where Malas the Durgapur Subdivisional Hospital Malas given the report. And this is the Malas final order of disposal. was page 72.
Hmm.
The last portion from the report forwarded by the superintendent of Durgapur Subdivision Hospital, it appears that a medical examination was conducted by a board on February 13, 2023. The said examination was conducted after more than 6 weeks from the date of passing of the order on November 30, 2022. Upon reviewing the medical history papers and conducting clinical examination of the petitioner, the medical board came to the finding that petitioner number 1 is an old case of operated cerebrovascular accident with right-sided hemiparesis and voice dysfunction. He was unfit for day-to-day activities at present. The scope for improvement within a further period of 6 weeks from February 13, 2023 was also unpredictable. After perusing the report, this court is of the view that petitioner is unfit, duty being permanently disabled, and the recommendation of the Apex Medical Board that there is a chance of improvement within 6 weeks cannot be accepted in view of the recommendation report of the Independent Medical Board. In such circumstances, they have been directed to consider my case. And everything has been decided. They have
Thereafter, an appeal was preferred.
an appeal is preferred,
Federal report.
Yes,
Where is that report?
And thereafter, a medical board of SSKM has been constituted, and another medical examination was conducted. Thereafter, kindly come to page 81. That is after the medical board submitted report before this honorable court. In view of the report filed by the medical board of SSKM, which shows that Mr. Lakahari has permanent disability due to operated case of cerebrovascular accident, parenchymal hemiparesis, hemorrhage,
And there was a direction for consideration of compassionate appointment being.
And it has been declared that I am permanently disabled. Thereafter, they have been directed to consider my case in view of the observation made. And thereafter, they have passed the reason order, and then contempt has been carried out. The reason order has been set aside. This is the second reason order. And the same points they have taken in the first round of litigation has been, they have taken here as well. So, they cannot sat in appeal over the decision passed by this honorable court. And again, raise the same points. Everything has been decided.
Yes.
But the implementation instruction is page 34 of the writ petition.
34
of the writ petition.
Writ petition. Yes.
Yes, my lord. And my lord, I would like to, since my learned brother has not annexed the writ petition, first round of writ petition, I would like to point out a particular point based on which these orders were passed. My lord,
whatever it is, now it is no use going back.
No.
A lot of water has flown down, right? Your
yes,
appeal against the order of the learned trial judge stood dismissed, and the Honorable Division Bench, in fact, declared that the petitioner is.
My lord, there is no dispute.
No dispute.
No.
Then what remains?
My
Why?
Lord, two points. My lord, in a similar matter, my lord has already heard this scheme, particularly this particular voluntary retirement.
I will not go to it because it has been decided.
No. It is on hold, my lord. It is not being provided.
It cannot be done. This bench is not in a position to hear or adjudicate your submission because it was submitted on the last occasion.
I shall point out one place. If my lord would not consider the reasoned order be a reasonable order, in case.
This order appears to be.
I would like to explain. I would like to have 1 minute time to explain why this is being done.
What is being done?
The reasoned order, why the reasons mentioned over there have been mentioned due to some reasons. I shall mention that only. I shall take only 1 minute. My lord, that is the reason I tried to point out in the writ petition, first round of writ petition, their primarily grievance was 50% salary. They
No
cannot sustain.
use going into that.
My
The
lord,
court directed for consideration of the petitioner's case for compassionate appointment.
Yes.
You cannot go back.
Even if I don't go back.
Yes.
He needs to get retired first. First, he needs to get retired. Once he is allowed, everything is done, then this scheme applies. Then the provision for application for compassionate employment comes after the retirement, after he is struck off, my lord, resulting in loss of employment. He is still in employment. He is still in employment. He is not refusing his salary. He is taking everything, the medical benefits, treatments, everything, my lord. And my lord, if my lord allows me, I shall submit a bit further. In case it is being considered and he is not given a job, then they will lose both. kindly does not record that portion. This is my humble submission.
Please come. The petitioner number 1
Let it be considered.
was serving the Eastern Coalfields Limited. Step. The petitioner number 2 is his son. Step. After a prolonged litigation before this court, the Honorable Division Bench on 28th February 2024, in the appeal preferred by the Eastern Coalfields Limited, being MAT 1630 of 2023, Can 2 of 2023, within bracket, Messrs. Eastern Coalfields Limited and others versus Lakhahari and others, directed that the recorded that the petitioner number 1, Lakhahari, has become permanently disabled. Stop. The said declaration was made by the court relying on the report filed by the Medical Board of SSKM. Stop. The court directed the authority to extend all monetary benefits to Lakhahari and to consider the prayer for compassionate appointment of his son. Robin Hori. Stop. The order passed by the general manager, Jhajra, JHNGRA area on 3rd July 2024, rejecting the 3rd/4th July. Petitioner's prayer for compassionate appointment is impugned herein. Stop. The ground rejecting the petitioner's application for compassionate appointment is that Lakhahari is being paid special leave allowance to the tune of rupees 56,000 per month, within bracket, on average, along with free medical facilities and reimbursements. Stop. Compassionate appointment can be granted only to tide over the immediate financial crisis. Stop. As Lakhahari is receiving special leave allowance, the ground of financial crisis does not apply. Stop. Lakhahari has been declared permanently disabled by the High Court, but he is still drawing special leave allowance without rendering any service. Stop. Lakhahari has 2 more daughters and another son who also claim to be his dependent. Stop. The general manager, paragraph diya hobe, mentioned that Robin Hori may apply for employment commensurate with his qualification as and when employment notification is published by the company. Stop paragraph. Learned advocate for the petitioner submits that the grounds taken by the authority to reject the petitioner's prayer for compassionate appointment is the repetition of the grounds taken by the authority in the earlier round of litigation. Stop. Prayer has been made to set aside the impugned order and to direct the authority to reconsider the prayer of the petitioner for grant of compassionate appointment. Stop. Paragraph. The aforesaid submission of the petitioner is opposed by the learned advocate representing the respondents. Stop. It has been submitted that compassionate appointment can be provided only if there is a loss of employment. Stop. In the instant case, there has been no loss of employment. Stop. The employee, that is Lakahari, is being paid special leave allowance every month. Stop. Paragraph. As there is no financial crisis in the family, accordingly, the prayer for compassionate appointment cannot be considered. Paragraph. Upon hearing the submission made on behalf of both the parties and on perusal of the documents placed before this court, it is plainly evident that the Honorable Division Bench, video order dated 28th of February 2024, directed the authority to consider the prayer for compassionate appointment of Robin Hori. Stop. The said order of consideration was passed by the Honorable Division Bench upon perusal of NCWA provisions and the report filed by the Medical Board of SSKM. Paragraph. At this stage, there is hardly any scope on the part of the authority to reject the prayer of the petitioner for compassionate appointment, reiterating the same provision of NCWA, which was not accepted by the court. Stop. The court directed the authority to extend all monetary benefits to Lakahari. Stop. The monetary benefit that has been extended to Lakahari, petitioner number 1, is in terms of the order passed by the Honorable Division Bench. Stop. The authority cannot re-agitate that there is no financial crisis in the family and the prayer for compassionate appointment cannot be reconsidered. Stop. There is also no scope to fall back upon the provisions of NCWA all over again. Stop. Paragraph. In view of the above, the court is of the considered opinion that the impugned order of rejection of the petitioner's prayer for compassionate appointment is not in tune with the order passed by the Honorable Division Bench. Stop. The same is liable to be set aside and is accordingly set aside. Stop. The authority is directed to reconsider the petitioner's prayer for compassionate appointment strictly in accordance with the order passed by the Honorable Division Bench and take a decision in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Step. A reasoned order shall be passed and communicated to the petitioners. Step. The formalities required to be complied with by the petitioners shall be clearly intimated to them. Disposed.
Well, only one intelligence, my lord. May I pray for 12 weeks?
12 weeks?
Yes, my lord,
See,
because
the division bench's order is long
my
back.
lord, he has been accepted, but my lord, time, competent approval, different departments, my lord. That is
Consider and then approval comes later on.
my lord,
Acha, make it 12 weeks.
yes, my lord, it will not take much time. And my lord, my lord,
Malas, there was a can malas that is become infructuous.
my lord, only one
12 weeks করে দিন can disposed.
My lord, only one submission I want to make, just for clarity. My lord, I shall ensure that his application for voluntary retirement shall be considered, and I believe it will be accepted. But, my lord, here comes the point of financial thing. He will be joining at 30,000 and
In
he is
the
getting
next
56,000.
round of litigation, please take these points.
My lord, that is the reason, my lord, I was agitating. He will be getting much less.
Item 10.
Deeply obliged.
Item 10.
I beg to appear on the petitioner, my lord. Because there was a direction of the last date to file an affidavit, my lord.
The affidavit could only finalize because at present there is no official authorized representative in the Malda division. The authorized representative has taken VR. At present there is no replacement. Now they are thinking of approaching their headquarters at Calcutta for affirmation of the affidavit and approval of the affidavit. So I am seeking further time to file the affidavit.
From April till June, and this is a matter seeking voluntary retirement.
And subsequently withdrawn. And then he did.
And you are sitting tight.
Lordship, the concerned official who was there, he has taken VR in second.
I do not repeat because whatever you have said, I have heard. You should have taken steps prior there too.
Also, I'm praying for last chance. They are approaching the Calcutta headquarters of Calcutta for doing the needful, Lordship.
Learned advocate representing the Union of India submits that there is none to affirm the affidavit that has been directed to be filed. Stop. The authority is intending to approach the officials of the Calcutta jurisdiction, Kolkata jurisdiction, to affirm the affidavit. Stop. Prayer has been made to extend the time for filing the affidavit. In view of such submission, the submission, time to file the report by way of affidavit stands extended till 10th July. Release the matter on 20th of July. Exception by the petitioner may be filed prior to the adjourned date. It is made clear that in the event the report is not prepared, and circulated within the time period mentioned herein above, the writ petition shall be decided on the basis of the documents already available on record. Next.
Grateful, Lordship.
Item 11, my lord, I am for the petition. There was direction, my lord, to file a report 25th May.
Please go before the Group 5 bench. This is Asha Konmi. You go before the Group 5 bench.
There was direction, my lord, to file a report.
Yes, I understand. Go before that bench.
Report has not yet filed, my lord.
I understand. Who will be there to file the report? The State Council is not there.
I serve the copy, my lord.
And the matter relates to engagement of to recruitment process of Asha. The matter is to be taken up for adjudication by the bench taking up Group 5 matters. The instant writ petition accordingly stands released from the list of this bench and be placed before the bench taking up Group 5 within bracket Panchayat matters. Leave is granted to the learned advocate on record of the petitioner to amend the presentation form and the front sheet of the writ petition.
This is the third round already.
Let notice be served upon the served in the office of the learned government pleader. Next.
I am appearing on behalf of the petitioner. My lord, on the last occasion was pleased to direct ECL to file a report. My lord, a copy of the report has been served upon me on this Friday, my lord. My lord, I want
My
to
lord,
give
we
an
are for the
exception to
ECL and we are
my
filing
lord.
report.
Report filed by the Eastern Coalfield by the
Eastern Coalfield Limited.
Eastern Coalfield.
Respondent number 227.
In court today be taken on record. Stuff. Learned advocate representing the petitioner seeks time to file exception to the same stuff. Let such exception be prepared and circulated within a period of 2 weeks.
2 weeks, my lord.
Release the matter for further consideration on 20th of July.
20th July.
Full to your lordship.
May report be also given to us. We are for the Union of India.
Yes. Let a copy of the report be served upon the learned advocate representing the Union of India.
Sir, number ta dena, what's the photo?
Here, what happened? My lord, my candidature has been rejected by the respondent authority on PST stage on shortfall of height. Thereafter, I approached before this honorable court. This honorable court was dismissed my writ application. I preferred an appeal before the honorable division bench. Honorable division bench was directed the respondent authority to reconsider my appeal, and after reconsideration, the order has been passed. My lord, my appeal was for
There was a direction for filing a report.
Yes, lordship, I am paying for the respondents, but I am paying for 2 weeks' time to file the report.
My lord, it is pertaining to recruitment process of 2024. On similar order, on the basis of similar order, the candidate has given appointment. Reconsider, remeasurement, height come under the ceiling permissible limit. Thereafter, medical done, given appointment. But my case, I am the sufferer. I have not been even given an opportunity of hearing, and the person who passed the order has no jurisdiction. This honorable division bench directed the respondent authority, somebody to consider my appeal. Another person, another authority has decided my issue. My lord, I am not standing on the way to file a
2 weeks' time, we will file the report.
April. You cannot get it as a matter of course.
Lordship, we have asked for the report. I'm just praying for 2 weeks' time.
But if the report is not coming, in that case, whatever is there will decide on the basis of this. Why?
2 weeks' time be given, we will file the report.
Why has it not been filed within 2 months?
Lordship, we have asked the report from the concerned
Yes.
department.
Where are the learned counsels?
My learned senior is out of station to attend to some personal emergency. And the junior counsel appearing in the matter, I am not able to contact with him.
Then how can you appear? You are not there are you there in the panel?
No, Lordship.
Then call Mr. Madhujana. He is appearing for the state in all matters. Call him.
Lordship.
Mr. Madhujana is appearing in this matter. He was outside of the court.
Yes.
Just now.
He is not.
Courtroom number 19.
He is not appearing in this
I
matter.
told him that this matter, I think.
Yeah, I can see
he
his
is-
Recorded in the order, however,
I
he is not.
I think he is not yes, because I am asked.
Is not appointed. Who is the junior counsel?
The junior counsel, I am not able to contact.
Who? What is his name?
Just Rumi Mukherjee.
11, Bar Association room number 11.
Call Rumi Mukherjee, room number 11. Call. Yes, next. Pass over.
Kindly give him 2 weeks time on parentary condition. Otherwise,
No, let me understand. Again, it will get delayed. Yes, next.
Here for the respondents, Union of
Yes.
India.
My lord, I am for the petitioner. I am cutting the matter short rather than speeding it like pack of cards. What has happened is that I am a medical officer of the Sashastra HON'BLE. Since my inception in my service, I was enjoying hospital patient care allowance. Now, till the 7th Pay Commission has also recommended for that. In 2025, 22nd July 2025, suddenly a memo has been issued that your hospital patient care allowance is not eligible to you. The reason shown is that I am getting no NPA. NPA means non-practicing allowance. So that is my case, but I am just placing the writ petition to them. I am just placing the.
Show me that the law permits.
Yes, I am showing the I'm showing the notifications of the central government. Kindly come to page 25 first. Thereafter, I shall place 24.
25.
This has been followed by the Honorable Delhi High Court in series of matters in respect of other petitioners also. 25 is memo dated 4th February 2024. Kindly come to page 26, clause 3.
What does this relate to? Payment of hospital patient care allowance?
Yes, yes.
To the Group C and Group D non-ministerial employees. Do you fall in Group C and Group
I am
D?
Group A, but subsequently this has been extended to Group A also, that I will show. But kindly come to page 26 once.
Yes.
Who are eligible for this? Clause 3.
Yes.
The conditions which an organization must satisfy before its employees can be reconsidered for grant of hospital patient care allowance. Only persons group C and D, non-ministerial employees whose regular duties involve continuous and routine contact with patients infected with communicable diseases, or those who have to routinely handle as their primary duty infected materials, instruments and equipments which can spread infection as their primary duty, may be considered for grant of hospital patient care allowance. It is further clarified that HPA shall not be allowed to, for any of those categories of employees whose contact with patients or exposure to infected materials of an occasional nature. Now, this is the first notification issued by the Government of India. Thereafter, kindly come to the earlier page, page 24. This has been extended to Group A and B non-ministerial staff. I am falling in level 9 and above. I am falling in level 9 and above. Thereafter, if my lord has seen that,
I don't know. Office memorandum. What does it say? In
implementation of recommendation. There is a recommendation of 7 Central Pay Commission. I should place that also for granting of hospital patient care allowance to Group A and B and also the allied medical services. Now, what they have done, they have excluded us and allowed only the allied medical. Who are the allied? Allied as the paramedical staffs. I am coming to the impugned order. I am falling in level 9 and above, rupees 5,300. Now, my lord, kindly come to the next memorandum, that is at page 29. This is the central government's view. The department cannot take a different view. Central government's view is that this is 24th August 2020. This memorandum has been issued by the department itself in 2020 when I was getting the hospital patient care allowance. There, HPCA admissible. That first paragraph is very clear on that. In fact, they all are following the 2004 memorandum. That is the principle.
Is your regular duty
Yes.
involving the contact with patients with communicable?
Yes, I am a medical officer engaged in these duties. And in several matters, the Honorable Delhi High Court has said that the department cannot impose a blanket ban on all the doctors. They must assess. There must be a finding whether I'm doing the duty or not. I may be telling a false statement, but there must be an assessment. So that must be there. Now, my lord, kindly come to page 33. There cannot be a blanket ban. That is what I am challenging. This is issued by the Ministry of Home Affairs, page 33, dated 20th August 2020.
Yes.
MHA, may I place it? MHA Police 2 Division, such and such, dated 17 January 2020, what I have just placed before your lordship, by which they have conveyed extension of the facility for granting of HPCA or PCA to all Group A and B non-ministerial employees, hospital staff, excluding nurses working in various hospitals of Central Armed Police Forces, National Security Guard and Assam Rifles. So the view of ministry is very clear. Now, my lord, kindly come to the impugned order. But before that, may I place 3 judgments of the Honorable Delhi High Court?
Let me see the impugned order first.
Impugned order at page 44.
Yes.
May I place it, my lord? May I place the second paragraph?
All right.
In this regard, various references have been received seeking clarification regarding eligibility of SSB medical officers with regard to admissibility of HPCA, PCA. The matter was examined in depth under consultation with Medical Directorate, Frontier Headquarters, SSB. Accordingly, it is clarified that as per existing guidelines says something else. For grant of HPCA, PCA to Group A and B, employees only allied healthcare professional, non-ministerial employees, excluding doctors and nurses, are eligible. Ministerial guidelines says something else. They are taking a different view. Now, my lord, kindly come to the various orders of the Honorable Delhi High Court in respect of other petitioners, not me. Kindly come to page 38. There, a counter affidavit is also filed by the department saying that the petitioner is eligible for HPCA. I shall place
Page
that.
29 also important. Page 29, 34 also important.
Please, I am arguing. She thought that I am not here. She thought that I am not here. Now, page 38, I am placing paragraph 4. Upon being issued, a counter affidavit has been filed by the respondents wherein it has been categorically stated that the respondents are obliged to release the PCA in favor of those members of the paramedical cadre or doctor who fulfill the conditions as laid down in the circular dated that 2004 circular issued by the Ministry of Health and Family Welfare. Now, I will kindly come to paragraph 6. What is the order passed by Honorable Delhi High Court? In the light of the aforesaid stand taken by the parties, we dispose of the writ petition along with the pending application by directing the respondents to examine the case of the petition. I am exactly praying this much. Let it be examined. There cannot be a blanket ban. Examine the case of the petitioners for grant of PCA in terms of the eligibility criteria set out in circular dated 2004 within a period of 4 weeks from today. In case they are found eligible for the same, they will be paid PCA on a month-to-month basis and the up-to-date matter areas will be paid to them within a period of 12 weeks thereafter. In case the petitioners is not made, payment is not made, such and such interest. Paragraph 7, the recovery has also been stayed. Here in this case, recovery has been started. That is why this matter was mentioned before your lordship just before the vacation, and it was put in the list as urgent motion. Since the recovery has already been initiated, I have stated in paragraph 17 of my writ petition that recovery has been initiated. Now, if my lord kindly comes to paragraph 14 of my writ petition, paragraph 14 of my writ petition, page 15. On or may I place it, my lord? On or about 4th February, on or about 4th February 2025, the Honorable High Court at Delhi in writ petition being WP number 1399 of 2020 was pleased to pass a direction upon the respondent authorities to examine the employee's eligibility in terms of.
Placed just now. This order you placed just now.
Yes, this I placed, but I have just pleaded one thing, that last line, this order said solemn order was passed on the basis of the counter affidavit filed by the respondent authorities.
All right.
And paragraph 17, I have stated that recovery has already been started.
All right.
And may I place that affidavit once?
No, it's all right. Let me hear the authority.
I am just praying this much. Let the case be examined. I may be saying something else, and the fact may be something else. Let it be.
There are several doctors I see, not one.
There are several doctors. They have given power to one doctor to proceed the case. The impugned memo has been issued by the 63 Battalion, Barashat. কোর্ট ফি দেওয়া হয়েছে পুরো কোর্ট ফি দেওয়া হয়েছে I am praying only this much. Let it be examined, and in the meantime recovery may be stayed.
No, court fee has not been paid.
Oh, I undertake to pay it in course of today. I undertake, my lord. I'm sorry, my lord. I'm sorry.
Firstly, kindly come to the prayer portion, page 21 onwards. The impugned order has not been touched. No prayer is there for quashing or setting aside. And secondly, my lord. Secondly, my learned friend has placed some office memorandums and some judgments and orders of the other honorable high courts, which are all on the prior position of law. What is not stated in the writ application is that subsequently the central government received some points of objection from the Office of the Comptroller and Auditor General. The reasons are also given.
No, that was prior to that.
On that basis, the matter was subsequently reviewed by the relevant authorities, and it was subsequently, the policy has been changed. It has been subsequently decided that the doctors will no longer be entitled to the allowance.
Where is the change in policy? Where are the documents?
Those are not parts of the writ application. The documents, parent documents, on the basis of which the order impugned is passed.
That is there.
Those are there. Kindly give us some time to file an affidavit in opposition. We shall disclose them.
Well, this is the latest view. Kindly see, this is the 7th Pay Commission report. Clause 11.
Commission report is different.
This is the government's view. The recommendation are there,
If
acceptance
the
are there.
government is recommending payment of this allowance, then why will the department say no, it will not be paid?
No, my instruction is that government is now recommending the payment. The 7th Pay Commission recommended.
Recommended. Then
Yes,
how
but
come
on
you
the
being
basis
the
of the
department?
on the basis of the objection of the Comptroller and Auditor General, the matter was reviewed by the appropriate authority.
Appropriate authority means?
The ministry.
How can that be? Because the government has passed an order.
My
7th
lord,
Pay Commission
I'm
is by
grateful,
the
ma'am.
ministry.
I'm grateful.
Kindly give us some. We have also.
Let it be examined rather than
Kindly
keeping
give
the
us
matter
some time to
pending.
file an opposition, my lord.
Well,
I have also asked the reward.
In that case,
My lord.
you have to stay
Page
the
29 is very clear, my lord.
Let it be examined. I'm praying for a simple prayer, making a simple prayer.
If
Recovery proceeding.
recovery has to be stayed.
My lord, I'm grateful, my lord.
We pass a limited interim order and give us the opportunity to file the opposition.
I was praying a simple order that let it be examined by them, by themselves.
Are medical professionals. Stop. They are aggrieved by the act and by the order of the Deputy Inspector General within bracket ORG, comma SSB, dated 22nd of July 2025, whereby the grant of HPCA/PCA caps to Group A employees.
Non-ministerial cadre.
Group A employees within bracket non-ministerial cadre has been held to be ineligible and only allied healthcare professionals within bracket non-ministerial employees, excluding doctors and nurses, have been found to be eligible for HPCA/PCA. Stop. The order clearly mentions that the doctors and nurses are not eligible for HPCA/PCA, and the same may be granted to only eligible personnel as mentioned in the Ministry of Health and Family Welfare's letter dated 4th February 2004. Office memorandum dated 18th September 2019 and 21st of May 2021, and the Ministry of Health Affairs Office memorandum dated 1st May 2023. Stop. Specific case of the petitioners is that the Honorable Division Bench of the Delhi High Court at Calcutta passed order in a similar matter on 13th of September 2024 in WP within bracket C 12921/2024 within bracket Kamal Kishore and others, page 38, versus Shoshostra Shimabol and another. Clearly mentioning that, directing the respondents to examine the case of the petitioners for grant of PCA in terms of the eligibility criteria set out in the circular dated 4th February 2004 within a stipulated time period. And if the petitioners are found eligible for the same, pay PCA on a month-to-month basis up to last arrears within a stipulated time period. Paragraph, it has been submitted that the respondent authority ought not to have passed a blanket ban order restraining grant of PCA to the doctors and nurses. The authority ought to have ascertain the eligibility for grant of HPCA/PCA prior to passing such an order. It has been submitted that the petitioners were already receiving the aforesaid grant, but the same has been. You have mentioned trying to recover. Is the recovery proceeding?
Subsequently, in 2026, memo has been issued.
Achha. That steps have been taken for recovery of the amount paid to the petitioners on account of HPCA/PCA. Prayer has been made to restrain the authority from recovering any amount already paid to the petitioners on account of HPCA/PCA. Learned counsel representing the respondents submits that the decision of the ministry has been reviewed and fresh order has been passed, relying on which
May I take your lordship?
relying on which the which necessary direction has been passed, restraining grant of HPCA/PCA to the doctors and nurses. Paragraph, prayer has been made to direct the permit the respondents to file an affidavit. Paragraph, upon hearing submission made on behalf of both the parties and on perusal of the materials placed before this court, it appears that a decision was indeed taken by the ministry for payment of HPCA/PCA to the doctors and nurses who routinely contact patients infected with communicable diseases, handle infected materials, instruments and equipments, and can spread infection. No document has been placed before this court reviewing the decision of the ministry. According to the respondents, further clarifications have been issued, for which direction has been passed to stop grant of HPCA/PCA to the doctors and nurses. Stop paragraph. To adjudicate the issue effectively, comma, the respondents are directed to file an affidavit disclosing all facts along with supporting documents within a period of
3 weeks.
4 weeks. Stop. It will be open for the petitioners to file exception to the report within a fortnight thereafter. Stop.
Make it 3 weeks, my lord.
Acha, 3 weeks. The respondents are now, as the petitioners were already enjoying HPCA/PCA for a considerable period of time, comma, accordingly, the respondents are temporarily restrained from recovering any amount paid to the petitioners on account of HPCA/PCA till 30th of September 2026 or until further order, whichever is earlier. Step. Release the matter for further consideration on 7th September.
And my lord, I undertake to pay the deficit court fees, my lord, in course of today.
Learned advocate representing the petitioners undertake to deposit the deficit court fees in respect of 38 petitioners in the course of the day.
I am grateful, your lord.
It is made clear that in the event the deficit court fees is not paid, আপনি এক কাজ করুন আরো একদিন বেশি দিন. In course of make it Thursday, 25th June. It is made clear that in the event the deficit court fees is not paid.
No, my lord, I will pay it, my
by
lord.
the aforesaid date, comma, then the impugned order passed herein, not the impugned, that the order passed herein shall be restricted only in respect of the petitioner number 1.
And my lord, let the appear as a to be mentioned so I can place the documents to the extent of deficit court fees.
Why
By
you
20
paid? The court is not disbelieving you. The court has given you time.
Yes, my lord, I will pay it, my lord. I will pay it in course of today.
My lord, I am for the Eastern Coalfield Limited. My lord, I am praying for a time to file report. Report has been ready, and yesterday we have shared with the department for final waiting. So kindly, I am praying.
Why yesterday you shared? The order was passed in April.
My lord, since the record was not available, it was very difficult from our side.
PF authority was also directed to file a report.
My stand is due to the elections, all these things, my officers could not. Report is only.
Please come.
So, just give me 1 week time. We shall file.
Learned advocate representing ECL and the Provident Fund Authority seeks extension of time for filing the report as directed to be filed by order dated 27th April 2026. Stop. In view of such submission, time to file the report stands extended till 10th July. Release the matter on 27th of July. Exception to the report may be filed by the petitioner prior to the adjourned date.
My lord, item number 16 to 19, I am paying for 1 week adjournment.
Your lordship, kindly say, my lord, it's ridiculous,
Yes,
my
yes,
lord.
I have
How many
prayed-
times they have, my lord, prayed for, my lord, submitting, my lord, exception. Your lordship,
It is his matter. Why are you so worried?
how many times your lordship kindly see? Day after day, my lord.
Assuming. But the matter is his, isn't it? If he doesn't choose to
Well,
file.
1 week time maybe can give.
If he doesn't choose to file, he won't file. The matter will get dismissed or whatever the order is will be passed.
And many times, my lord, order was given, my lord, to file, my lord. Exception, my lord.
Exception has been
filed.
On the
So
prayer
many
of
times,
the
my lord.
On
the
the
last
prayer
item
of the
number
learned
18 and
advocate.
19, I have
Last
affirmed
time.
and served it.
Yes, my lord.
But
And
I missed the brief, and 16 and 17 I could not file the affirm the my lord, they prepared, but
16 and 17
Seven-
want extension.
1 week extension
Learned,
for filing.
the prayer of the learned advocate representing the petitioner, comma, time to file the exception stands extended till next Tuesday, 30th of June,
Yes, yes.
or some more days.
My lord, I contact, he told me, my lord, though both the candidate told me, my lord, they are out now, at present also out of his house.
Then
My lord, he told me 1 week, maybe the situation will be changed and he may come.
10th of July করে দিন. Release the matter on 20th of July. 16 and 17 this
17,
order.
yes, yes.
And 18 and 19 only not
18,
today.
19, I have only, not this week, my lord.
Not this
Not
week.
this week.
Used exception.
I have filed my.
As of 18, they have used exception. We have got it.
Yes.
18, 19, both, my lord, I have filed my.
19 were there. I keep it on Tuesday.
My lord, next week, any day.
Next week, Tuesday.
Your
Not
lordship.
this week. I make it only not
Oh.
this week. Let us see what happens.
My lord, item number 13, my lord, Miss Mukherjee is, I think, is.
Yes.
13 my lord. Their audit is out of Calcutta. And
There was a direction for filing the report on 22nd of April 2026 that has not been filed till date.
But actually, we are not in this matter.
You are not there?
No, not that. Mr. Ajoy Chowdhury is appearing in audit.
Just now, the learned counsel said that you are there. I can see Mr. Madhujana's name recorded over here.
My name is wrongly recorded, my lord. I have,
Who will be there?
my lord, Mr. Ajit Chobe and C. My lord.
And then she says she's not there.
My lord, I have searched, my lord. The appointment letter is not with me, my lord. The engagement letter, my lord.
Kindly some time.
But then if you are not there, if you say you are not appearing in the matter, in that case, your submission cannot be recorded also. Are you sure you are not there?
My lord, my lord, let me clear, my lord. My lord, this endorsement, my lord, gives from the Ministry of Law and Justice. This endorsement is sufficient for us. My lord, Mr. Chandri Alam Gupta and Runu Mukherjee. She is appearing, my lord. She is appearing, my lord.
If Miss Alam is there, then where from is Mr. Chobe there?
Chobe, my lord, Mr. Chobe's name has wrongly, I think, my lord, this is wrongly reflected, my lord. My name, Mr. Chobe's name and mine is wrongly reflected. Because, my lord, the Chandri Alam Gupta and the Runu Mukherjee.
I saw Miss Alam over here just now. Where is she? I just now saw her.
Just put number 4, my lord.
Put number 4, she's gone.
My lord, let it be, my lord, not this week, then, my
Not
lord.
this week, my lord.
Civil, my lord.
All right, not this week. Nothing mentioned in the order, only not this week. You inquire who is there and whether the report can be made ready.
Yes.
All right.
Obliged, my lord.
But then, do I delete your name?
My lord, that is.
একটা order record করুন তো. It has been brought to the notice of
My
the
name and
court
Ajit Chobe's name, Mr. Ajit.
that the appearance of the learned advocate representing the respondents in April. It was wrong. You were not there in April also.
My lord, I'm not there because, my lord, I have.
And Mr. Chobe was not there in April
there.
also.
His junior has said. No, no. It's not.
Has been wrongly recorded in the order dated 22nd of April 2026. Appearance slip গুলো আমি এই কারণে রেখে দিতে বলি। আপনিও দেন না? Stop. Let their appearances be deleted.
তবে সেদিন কিন্তু অনেক বড় মামলা হয় চৌবেদা দাঁড়িয়েছে
Release the matter on 29th.
Next
Monday.
Next Tuesday. Oblige, my lord.
Wait, please.
Yes.
After this one, not after the petition.
Has any instruction come?
My lord, till today, no instruction has come. They paid for another time because it will come from Delhi. They take
Why
time.
did it come from Delhi? The transfer order is passed by which authority?
It is Delhi. DG Delhi headquarters. Director General Border Security Force.
But then the petitioner is supposed to go back by tomorrow. Today. By today. And if the instruction is not there, how can the matter be taken up?
My lord, they are taking time, sir. They requested.
But here your lordship may carry recollect, my lord, that matter, my lord, where the transfer order was cancelled subsequently.
I remember everything.
In that event, my lord, if they pray for time, my lord, এরকম ভাবে করবেন unless ধরুন এক দুটো তিন
What is the officer saying?
TPM.
Very well. Prior to rising, in the midst, it cannot be done. You somehow get the instruction prior to rising. I'll take it.
as your lordship, please. Great.
Next one, please.
I'm appealing for the petitioner. 20.
20 number.
20 to.
Oh, 20 to 22. All right.
20 is, my lord,
এটাকে সরান।
the issue here is as to whether a candidate can give an EWS certificate and can that EWS certificate be considered in respect of, my lord, years subsequent to the years of recruitment. EWS certificate has to be prior to the year of recruitment.
The advertisement, please.
Yes, kindly comes to page.
Is the state here?
Yes, yes. Page 15.
Report. Has copy been circulated?
Yes, yes. Page 15 is the advertisements for the post of constables in West Bengal Police.
Page?
15.
This
Of
is
the writ petition.
This is Sudipta Chakraborty of the writ petition.
This is writ petition is Sudipta Chakraborty. Yes.
I was looking at the can. Yes.
Kindly comes to clause B. In terms of memorandum dated such and such of backward such and such, the candidates from economically weaker section EWS, if shortlisted for interview, must produce income and asset certificates issued by the competent authority valid for the year 2023-2024 or onwards within bracket issued for financial year 2022-2023. So therefore the interpretation would be 2022 to 2024 at best. Lordship is there, clause B, Lordship has seen. Now, my lord kindly sees.
Yes.
Page 16, if I don't show, this will be shown to your lordship. Kindly comes to page 17, note, last clause.
Yes.
Candidates belonging to the economically weaker section must produce income asset certificate issued by the competent authority as per specific format valid for the year such and such 23-24 or onwards issued for the financial year 2022-2023 onwards. So 2022 to 2024 at best. It should have been 2022-2023 because recruitment process is 2024. Now, my lord kindly sees there was an editing window, but still the editing window cannot supplement. Now, my lord, same recruiting authority kindly comes to page 30. Issues another notice. In respect of constables, this is in respect of constables in West Bengal Police. the issue.
Hmm.
Page 30 is constables stroke lady constables in Kolkata Police. There, kindly see clause B, same copy paste in the font, but the date is date of issuance of such certificate must be between 1/4/2023 and 31/3/2024. Appropriately done. Candidates seeking such and such, such and such. Now what they do, kindly now comes to page 54. When the candidates are required to, my lord, give the certificates, this is what is being shown in the portal.
Must be on or after.
On or after.
After means there is
Ad
no age
ad
to it.
infinitum. Now kindly comes, first kindly comes to page 58 and thereafter to 57. E is income and assess certificates for candidates belonging to EWS category valid for the year 2023-2024, which they say was erroneously issued.
Which is erroneous? This one or
This one.
This is erroneous.
Yes.
58 is erroneous.
58, they say we have erroneously issued that, it should be 57. Now kindly comes to page 57. Previous.
And this is in connection with the Kolkata
Same.
West Bengal.
Same. They have said.
West Bengal police.
West Bengal. We are with regard to West Bengal. Only Kolkata for showing the. Now they altered that to E and
Onwards.
add or onwards.
Hmm.
Now, my lord, the addition of party application has been filed by my lord, Mr.
Whoever,
Constable,
yes.
where one document has been annexed, wherein it has been sought to be contended. Kindly take scan 2. Somesh Kumar Ghosh, and kindly comes to page 66 of that document, of that connected application. Yes.
Yes.
This was for upgradation. Period for updation of category has been extended to 21/12/2025. Candidates who have already changed their category will also be allowed to modify the same once again in case of inadvertent error on that part from 10 AM to such and such. So this was only for editing. My contention is that the crucial date, as has been, my lord, enumerated in the
let me understand this.
Yes, this was subsequently issued.
Page 66 is for editing by the candidates.
Yes.
Not by the authority.
No.
Right. So for the authority, they hold it that it will be 23 onwards.
Last, page 57.
23 onwards.
Yes, 23 or 24 onwards. Page 57.
23, 24 onwards.
4 onwards. So therefore, recruitment process is 2024. Principally, it should be prior to the year of recruitment. Circulars, Supreme Court judgments, everything is saying so. Now, my lord, lastly, it boils down to 2023, 2024 or onwards. So, ad infinitum till 2026, 2027, 2028. Now, my lord, kindly takes your lordship was pleased to issue was agitated before lordship in respect of second SLST. ওই ইয়েটা কমলা ও সব জানে,
এটা তো জিজ্ঞেস করছি কমলাকান্ত
ও সব জানে। ওই তো ছিলিস না রাতুল ছিল। But may I just বের কর, this is not right. কালকে বলে দিলাম তোকে, wasting the time of the court.
Yes, please.
Now, my lord, may I just place it, my lord, my junior is finding out. My lord, here the persons, candidates who had the certificate of subsequent years approached saying that, look, we were not able to get the certificate in time in view of the fact that it was been delayed by the authority. There your lordship has been pleased to hold The court is of the considered opinion, had the petitioners obtained the certificate prior to the last date of filing of the online application, then they could have got the option of upgradation editing their applications from in terms of the addendum notice issued by the commission. Here, none of the petitioners possess EWS certificate till the last date of filing of the application. In fact, from the chart annexed to the writ petitions appears that online applications for obtaining EWS certificates are made long after the deadline of filling up the such and such. If the benefit of reservation is directed to be granted to the petitioner, the similarly circumstanced candidates who receive their certificates after the last date of filing of the application on the online from may be deprived of the opportunity for being treated as reserved category. The rule according to which the reservation benefit is granted to the candidate prescribes that reservation certificate ought to be issued by the competent authority on or before the last date of receiving the online application. Allegation of the petitioners that commission permitted upgrading, editing reservation status of the candidates after the last date of filing application from the form contrary to the rules does not imply that the candidates who obtained certificates after the last date could edit their options relying on those certificates. Only if the certificates can be available prior to the last date of filing of the application form, then the question of updating, editing of the option arises. Any certificate which is issued beyond the prescribed period cannot be relied upon. Ram such and such, Roshib has been pleased to rely upon and discuss the judgments. One cannot be equated to other. Caste of an Hindu, caste certificate cannot be equated. On the other hand, paragraph 29, EWS certificate is issued to persons belonging to economically weaker section of the society. The same is issued relying on the assets possessed and family income of the certificate. The income of the family is usually not static and it keeps on changing, on fluctuating from time to time. It is only for the reason that EWS certificate is valid for a period of 1 year. The certificate is issued afresh if the same economic condition persists. EWS certificate has nothing to do with the birth of the candidate. The Honorable Supreme Court is Mohan Kumar, and Lordship has discussed Mohan Kumar, Dibya is the main judgment, and Dolly Chandar for the last date. In paragraph 32, Dolly Chandar, the court reiterated the principles. General rule is while applying for the post, a person must possess the eligibility criteria on the last date fixed for such purpose. There can be no relaxation unless there is an express provision contrary. In the instance case, the petitioner did not possess EWS certificate on the last date of filing the application form. So there's a crucial date. Now, my lord kindly takes up the affidavit in reply or the exception. Here, my lord, an FAQ has been annexed because everything is coming from the main circulars of DOPT. This entire thing, criminal, non-criminal, first is the main judgment where criminal, non-criminal came, and thereafter the interpretations. Now, kindly takes, my lord, the FAQ on the main circular. Page 12 of the exception. In the Sunny judgment, sorry.
Yes.
I was not.
Exception.
Exception.
Yes.
Page 12.
Service has not been made.
No.
Hand over copies, please. Service.
You will not be served. It has to be given to them.
Yeah, give copies. State council.
Kindly comes to page 12.
Yes.
You have not yet been added. Page 12. Kindly comes to page 12. To the chief secretaries, all state government and UTs. This is 2022. Now kindly comes to question number 21 at 16. Judgment.
Yes.
16. Question 21. Crucial date for income and asset certificate. Answer such and such. DOPT OM dated 31st January 2019, the main DOPT provides OM that the crucial date for submitting income and assets certificate by the candidate may be treated as a closing date of the receipt of the application for the post, except in cases where crucial date is fixed otherwise. Here it has not been fixed otherwise. Crucial date for submission of income and asset certificate within bracket cutoff date shall be clearly mentioned in the advertisement published by the recruiting agency. Income and assets certificates issued subsequent to the crucial date and for the later financial year shall be treated as a major discrepancy. In this regard, the order dated such and such passed by the Honorable Supreme Court is relied upon. Now, this has been reported 2022 4টা দে কালকে যেটা দিলাম এইটা কালকে যেটা দিলাম This is 2024 2 SCC page 605. এরপরে দিবা 2024 2 SCC page 605. এটা হচ্ছে UPSC versus Guru Gaurav Singh. UPSC versus Gaurav Singh. Paragraph 7, the main DOPT circular is being interpreted. 7, 16, 19, 20, 22 and 23, last part. May I just please? In terms, paragraph 7, my lord, first.
Is there any paragraph? I do not see paragraph number.
UPSC, it's a paragraph number. Gaurav Singh, UPSC versus Gaurav Singh has been given
Yes,
to
yes, 18th May 2020.
Yes, 18 may kindly comes to the internal page of 609, internal page of the report.
This is not the reported judgment.
Report statistically. Kindly text, my lord. I have marked, my lord. I'll share this comes in hand. Sorry for the marking, my lord. This is unreported. Kindly first sees paragraph 7. In terms of the notification dated 31st/1/2019 referred to above, the benefit of reservation under EWS category could be availed upon submission of income and assets certificate issued by the competent authority for the financial year prior to the year of application and closing date of receipt of the applications for the post as to be treated as the crucial date for submission of income and asset certificate, except in cases where different crucial dates was fixed. Now kindly comes to the other marked portions are there, but the main part will be that is with regard to, my lord, facts where there was errors in issuance of the asset certificates. Competent authority had not issued. Some of the asset certificates were, my lord, allowed, some were disallowed. Now why the certificates which were disallowed have been, my lord, stated in paragraph 18. Paragraph 18, a technical irregularity in the certificate issued by the competent authority in respect of the correct financial year cannot be equated with an income and assets in respect of different financial year where the income and assets for the particular financial year prior to the year of submission of the application goes to the root of eligibility of a candidate to qualify in the EWS category. So therefore, ideally it should have been prior. Now in this recruitment process, it has been extended for another year. Even if that's so, then, my lord, that year, my lord, that cannot go beyond 2024. Now, my lord, the respondent writ petitions were well aware that they had furnished, my lord, on the merits, my lord. Now, paragraph 22 has been marked there, my lord. It is not marked here, so therefore I cannot. I think paragraph 22, last part, I think. This is last part. However, in case of the respondent writ petitioners 2 and 4, the certificates are in respect of subsequent financial years as observed. In our considered opinion, the High Court fell in error in directing that all the writ petitioners be treated as EWS category candidates, even though the respondent writ petitioners 2 and 4 were ineligible in terms of the notification in that they had filed certificates relating to later financial year. The High Court ought not to have extended the time for submission of the certificate. Now, coming back again to, my lord, the notification. Page 15.
Yes.
Now kindly comes to the date which was the closing date. Date was Page 20 তে আছে। Yes. Clause 10, page 20. Period of application. Application window for submitting application through online mode only will remain operative for the period of such and such to such and such. So therefore 5/4/2024 would be the last date. Now, my lord, in the report that has been filed by way of an affidavit, in paragraph 18, রিপোর্টটা দিন না সাহেবকে, ওদের রিপোর্ট যেটা ওরা ফাইল করেছে।
Yes, paragraph 18.
Rashib is the report is there.
Yes.
Yes. Paragraph 18. Lordship was pleased to direct them to file a report indicating how many persons have, my lord, been filed the EWS certificate of the subsequent year. Paragraph 18 is the answer. That a total number of 914 candidates submitted their EWS certificates valid for 2023-2024, issued for the financial year 2022-2023, and total number of candidates of 1775 candidates submitted the EWS certificate at the interview valid after the year such and such. So therefore, in my humble submission, these 1775 candidates are they cannot be, my lord, constitute to be EWS category, and that will be, my lord, lowering the competition for us so that we can get. This is my contention before the lordship.
Yes.
But another point, my lord, that my junior is saying, my lord, some of the কোথায় বলেছে, some of the certificates Oh, yes. Another, yes. Another point, yes. Page 52, lordship would see that 54. I have drawn your lordship's kind attention to this. I'm sorry, my lord, I didn't say
Page
this.
54.
54 of the writ petition.
Yes.
Now, my lord, if the certificate is from 1st April 2022, that is necessarily a certificate of the previous financial year. So that cannot also be taken up. That would be contrary to the notification itself. So it can be 2021 certificate. Main ought to have been 2022-2023. Maximum, they may argue that since you have seen the notification and participated, 24 can be taken, but not beyond that. And that is also on the last date of, my lord, the closing window of the application. These are my submissions, my lord. I have another judgment, my lord.
1 minute.
Yes.
Page 15, the advertisement.
Yes.
The date of publication is the date mentioned anywhere?
Date of publication of the advertisement.
Yes.
My instruction is 5th March 2024. Just yes, it is there. I have material to substantiate it. I have material. Kindly comes to
5th March.
5th March. না material দেখাতে হবে না
এতে আছে
আচ্ছা, yes, in the retired report also it is there.
5th of March 24.
Yes.
Because the opening window was 7th March 24
Yes,
till 5th of April. So it is 5th of March
5th March, yes.
2024.
5th March is
it
the
was published.
But I had more material. That is the website. Report it is admitted.
All right, then
Report it is admitted.
5th March 2024, the advertisement was published. It was for a period 2020, issued for the financial year 2022-2023 onwards.
Maximum 2023-2024, because the first line says 2023-2024. And in any case, has to be prior to the date of the last window. That is,
I get it. Yes.
Not prior to that, not after that. Last window date.
You were relying upon certain precedents.
Yes, well, I have given your lordship's order. Thereafter, the UPSC versus Gaurav Singh and Divya is there. If your lordship wants, Divya, your lordship has already relied upon. I can also give Divya. Divya is the judgment lordship has relied upon. Only one paragraph if your lordship wants. Yes, Divya.
Conclusion portion, paragraph 94 onwards, you'll get it.
Yes, 50 and thereafter 94.1. Based on such and such, this is the interpretation, was justified in rejecting the application who have claimed benefit of EWS certificate. They have, yes, 94 are the, as a sequel, the conclusion of such and such. The main thing would be crucial date. It goes back to the crucial date.
All right, you find out, let him make
Paragraph
submission.
42. The OM has been, it has been subsequently interpreted also. Paragraph 42, third line, the OM also makes it clear that the crucial date for submission of income asset certificate by the candidate may be treated as the closing date of the receipt of the application, except where it is crucial date is otherwise. So closing date.
Paragraph 42, you said?
Yes, paragraph 42.
And 94 is definitely there.
Yes.
All right, private respondent, you all have not been added as yet.
Yes.
Anyway, what is your case? How do you say that you all are eligible to participate in the recruitment
advertisement
process?
is very clear. Neither of the party, this advertisement published on March 2024. We are in 2026.
When were your certificates issued?
After 2024, admittedly.
Last date for filing the application is
yes,
5th of April.
Yes, after that.
After 5th of April?
After 5th of April. I'm not disputing on that.
Assuming it is after 5th of April, how do you say you are eligible?
Yes, Malad. Why I'm saying?
Yes.
Malad, kindly consider a certificate issued on 1st March 2024.
Yes.
This certificate relates to 2023-24.
Yes.
Maybe issued 1st March or afterwards. Simultaneously, if I obtain a certificate in 2024 June, this certificate relates to 2003-2004. Prior to recruitment. Though the certificate I received during the recruitment process, but the period for which the certificate has been given, that is prior to recruitment.
So, on the
that
date,
is the reason.
On the date, let me understand, on the date the application, the recruitment notification was published, you did not know whether you will get the certificate or not?
Not. Yes.
So, everything was very vague. Thereafter, you obtained a certificate and you claim to be eligible from a post facto date. Is this the case?
That is the certificate is. That is the certificate is. Certificate is given for the post facto period.
That means you acquire your eligibility after the closing of the date, last date of filing the application.
Yes, there is no dispute on that. There is no dispute on that.
Don't you think this is contrary to the judgments passed by the Honorable Supreme Court?
In the Honorable Supreme Court and before your Lordship sought in Kamalakanto matter, in that cases, the advertisement was separate. The advertisement specifically states that you have to produce the certificate on or before the last date of the online application. But here, the advertisement itself says the certificate is valid on and from 2020-24 or onwards. They have given me opportunity. They have given me opportunity, and this notification is of March 2024. This was challenged. The persons who have challenged this notification as on date, they appeared pursuant to this notification. All along they pursue it. When they failed to qualify,
applicants got their certificates after 5th April 2024.
Yes, admittedly. This advertisement is still today not challenged before your Lordship. Even in this writ petition also. They have not challenged the notification of the advertisement notification, recruitment notification. What they have challenged by which interview letter was issued.
If you also kindly see the challenge, the prayer of the writ petition.
Interview letter was issued to whom? To you?
To me and others.
And others.
That is page 57. 20th January 2006, 26. The interview of the fit candidate in PMT PET will commence on and from 29 January 2026. The e-call letters for the same can be downloaded from through and through portal. But here the clause E says, income and asset certificate for candidate belong to the economically weaker section, valid for the year 2023-24 or onwards. Similar thing has been written in the lots of the recruitment notification. They have not challenged. But I'll now kindly see what they have challenged in the repetition of their prayer. The first prayer is to read in the nature of mandamus commanding the respondent authority and each of them to coerce and set aside action decision of the concerned respondent in accepting non-relevant EWS certificate pertaining to the recruitment process of 2024. First prayer. Second prayer is a writ in the nature of mandamus commanding the respondent authorities and each of them to coerce and set aside the notification dated 20th January 2026. Number, they have not challenged the recruitment. They participated in the recruitment. When they failed to qualify in the interview, now they have come with this instant writ petition where the clause is the similar. In the recruitment notification, the clause is very clear and similar to the interview notification. We have participated in the selection process pursuant to the recruitment notification itself. There's in your lordships or in Kamalakant and Honorable Supreme Court, they are specifically barred that you cannot appear. But same thing has been happened in the recruitment process conducted by the same authority in case of Kolkata Police. In West Bengal Police, they have given option to onwards candidates, but in regards to Kolkata Police, but they have restricted up to a particular date. That has been relied by my senior friend in the writ petition. Not kindly see that notification also issued by the Kolkata Police. Not kindly see page 31, the notification of the Kolkata Police, and see the notification of the West Bengal Police. Same authority, the recruitment board.
But the criteria is different.
Criteria. EWS
criteria is different.
Yes. But kindly see page 31. The kindly see clause B. Fourth line from the top. The financial year 2023-24 or onwards during checking of testimonial on the date of interview. The date of issuance of such certificate must be between 1st April 2023 and 31st March 2024. There's a specific, these things have not been given in the notification of the West Bengal Police. But this has been the knowledge of the writ petitioner in the first inception because he appeared in both the selection process. He appeared in the West Bengal Police selection process. He failed to secure. In Kolkata Police process, he failed to secure. And the year 2026, after 2 years, when the entire process has been completed, interview completed, everything completed, we are waiting for our appointment letter. At this stage, they filed the writ petition without challenging the recruitment notification by which they appeared without any demand.
যে যদি কাট অফ ডেট না থাকে লাস্ট ডেট অফ সাবমিশন
কোথায় আছে
19 সালে 23 সালে যেগুলোতে আর ওই ডকুমেন্ট নোটিফিকেশন গুলো তো কাট অফ ডেট দেয়া আছে কমলাঘাট এসএসসি তো কাট অফ ডেট দেয়া না থাকলে
that will be treated as
লাস্ট ডেট এখানে তো কাট অফ ডেট বলে দিচ্ছে
নোটিফিকেশনটা অ্যানেক্স করে নিও না কিন্তু জজ সাহেব যে শুনে নেবেন আমি বুঝবো কি ওখানে জাজমেন্ট নিয়ে আসতাম এনে আছে তোমার কাছে So that is my case. Now, another thing is that the state has filed a report. If you lordship kindly see the report once. Let kindly see page 10 is the lordship the recruitment rules of the West Bengal Police. There is a specific recruitment rules for the West Bengal Police. Number kindly come to page 15.
Yes.
The page 15 is the paper publication. In the paper publication also, you also will find they have specifically stated, not may I show to your lordship.
Five.
But kindly see 5. Serial of
Onwards.
candidate belong to economically weaker section must produce income as a certificate as per format 2020 onwards. In every paper publication, they have specifically mentioned that. Nowhere the recruitment notification has been challenged. And another thing annexed by the state and relied by the state, that is page 22. May I read for your lordship? With reference to his memo now.
1 minute, 1 minute, 1 minute.
Yes.
Yes.
At page 22. This has been issued by the Joint Commissioner for Reservation to the West Bengal Police Recruitment Board for clarifying the detail of the accepting of the any caste certificate or certificate. With reference to the above, on the subject mentioned above, the undersigned is directed to inform him that a reserved candidate is entitled to get all the benefit of reservation from the date of issue of caste certificate.
This is caste.
After the
Caste
application is
different.
submitted and during the recruitment,
Don't rely upon this.
this has been relied by the state.
Doesn't matter, but this is regarding caste. Here the issue is not with caste. EWS and caste are completely different.
This has been relied by the state.
Doesn't matter.
But this is my that there is no challenge to the recruitment notification. The recruitment process is very specific. After participating in recruitment, when they fail to secure in the recruitment process, now challenging the interview letters, the call for interviews without challenging the recruitment notification, where the detail of the economically weaker sections are similar in the recruitment notification as well as the calling for the interview process. Firstly, my lord. Secondly, the petitioner knows on the very inception that there is a difference between the Kolkata police notification and the West Bengal police notification, though issued by the same recruitment body. That means he specifically on the date itself, because he appeared in both the recruitment process. So there is a difference. So he did not challenge us.
All right. Yes.
And in your lordship, in the SSC matters and others, your lordship has passed an order in Kamala Kanto. There the specific date was mentioned for the Home Ministry.
All right.
That's all.
Yes. What does this onwards mean?
I shall be drawing your lordship. Kindly see your attention. Page 17. Kindly see. Page 17 of the writ petition.
17. Yes.
At the bottom. Of the writ petition. At the
bottom.
Candidates belonging to economically weaker section must produce income and asset certificate issued by the competent authority as per specified format, valid for the year 23-24 or onwards, or if a candidate shortlisted for physical measurement test and physical eligibility test and or thereafter under EWS category fails to produce the valid certificate at the time of interview, his candidature shall be rejected. So at the time of interview, physically the certificate was required to be produced. Who did not produce at the time of interview, then his candidature would be cancelled. Now your lordship has seen the cutoff date 23-24 or onwards.
That means there is no cutoff. The moment you say onwards, it becomes open-ended.
No, certificate issued by the competent authority has to earmark that this certificate is for the year 23-24.
Or onwards.
Or onwards.
What does this mean?
Now that has been clarified. Your lordship.
All right.
Yes. Now another page I shall be drawing your lordship's kind attention. That is page 25. Page 25 of the writ petition. That middle portion, small I, interview.
Yes.
Candidates qualify for interview must submit their caste or category certificate to change his or her category form. You are so and so, request for change of category will not be entertained after the scheduled date of his/her interview. So that at the time of interview, whatever certificates the candidates are in possession, those are required to be produced before the interviewer. Now, thing is this, not I shall now not draw your lordship's kind attention to the report filed by the state. But in identical matter, not a coordinate bench of this honorable court that passed an order that appearing at page 48. Will you kindly have it? Page 48.
Yes.
And 48 and 50. But I am just reading out one page order. The report submitted by the respondent kept with the record. Learned counsel for the petitioner submits that in terms of the notice dated 20th January 2026, the grievance of the petitioner has been fulfilled, wherein it is mentioned that income and asset certificate for candidates belongs to economically weaker section, valid for the year 23-24 or onward. As the petitioners have satisfied the petitioner's grievance has been fulfilled, thus no order can be passed in the present writ application. The petition is disposed of.
There is no adjudication of any issue in this matter.
Because initially there
Possibly certificates were not issued, and that is the reason they approached the court. The moment certificate is issued, the court disposes of the matter.
There was an error. Initially there was an error that was rectified. Lordship sees page 50 also. Learned counsel for the state has filed the report after serving the copy of the so-and-so. Learned counsel for the petitioner has handed over the notice issued by the authorities dated so-and-so, wherein clause E states that income and asset certificate for candidates belongs to economically weaker section valid for the year so-and-so onwards. Learned counsel for the petition submits that this notice has been issued with respect to the post of constable, but the present application is for the post of sub-inspector of police in the state of West Bengal. He submits that if the authorities issue this same notice with respect to the post of sub-inspector of police in the state of West Bengal, the petitioners will be satisfied. Learned counsel for the state on instruction submit as the respondent will issue the same notice with respect to the post of sub-inspector of police in the state of West Bengal accordingly so as to dispose of. Now, if your lordship kindly sees the report, that I am just drawing your lordship kind attention to starting from, I shall just draw your lordship kind attention to paragraph yes, paragraph 3. First, your lordship kindly see paragraph 3, that the aforementioned notice was published on 5th March 2024 and the revised notice was published on 6th March 2024, just one day after, by the West Bengal Police Recruitment Board, inviting applications from eligible candidates for filling up the post of constable in West Bengal Police 2024. The details of the eligibility criteria and the entire recruitment process were provided in the information to applicants, which was made available on the official website. Now, your lordship kindly see these dates are important. That's why I am placing this paragraph. Now, your lordship kindly have a look to paragraph 11 onwards. Paragraph 11 onwards. That of the report. That any candidate who applied under the EWS category has received reservation benefit from 30th November 2025 onwards in this recruitment drive. The requirement regarding the validity of the income and asset certificate for the year 2023 to 2024 or onwards issued for the financial year 2022-2023 or onwards does not conflict with the reservation policy and the period for validity of EWS certificates as advertised in the information to applicants. That the aforementioned criteria were clearly reiterated in another notice bearing number so dated 20th January 2026, which clarified that the income and asset certificate for candidates belonging to EWS must be valid for the year 2023, 2024 or onwards. Now, Lord, as per my instruction, Lord, which Lord, I should submit before your Lordship, that onward means, which is troubling your Lordship, onward means till the date of interview, not beyond that. Till the date of interview, the candidates who are having the certificates for the year 2023-2024 till the date of interview. So those were accepted. So I do not find, subject to your Lordship's kind consideration, I do not find any illegality or impropriety in the process of recruitment. The date of interview was scheduled on 29 January 2026 to February 2026, end of February.
29th January 26 till
February, end of February.
28th of
February.
28th of February 2026 for 1 month.
For 1 month. So the dates for interview were scheduled between this time. Now, thing is this. So, the persons who have been selected, appointments are awaited for this. The persons who have been finally selected, they have not been issued any appointment letter. So, till now,
result published. Result published.
Result has not been published. Result has not been published. No appointment has been given as yet. But there is no error in the process of recruitment.
Tell me one thing.
Yes.
This income certificate, or rather the income, it is the SSC matter I have mentioned that income of a person is never static, and that is the reason there is a requirement of regular issuance of the income certificate because it is valid for only one particular year. Caste certificate means you are born on a set day and it continues. This notification for recruitment was published in March 2024. A candidate who applies in March 2024 will never know whether in, say, 29th January 2026, whether he will possess EWS certificate or not. How will you consider his candidature?
Cut-off date for production of physical production of the certificate, that is EWS certificate, is on the date of interview.
Right. That means for the entire period from when the candidate files the application till the date of the interview, till he obtains EWS certificate, he does not get the benefit of reservation.
Because that is not required at the time of application. That is not required. He can only apply that under which category he or she is applying. But
he seeks reservation.
Yes.
Suppose a candidate doesn't have the certificate, he can very well appear as an unreserved category candidate. Always.
With the expectation that he would be issued.
That means ifs, buts, question marks is there.
Not if, but not if I may be permitted to say this, that he has applied for EWS certificate.
He doesn't know whether he'll get or not because the competent authority will take a decision whether to issue a certificate in his favor or not.
In that event, he will not come under the zone of reservation.
Yes. That means he doesn't get the benefit of reservation.
No, he will definitely be rejected as the EWS candidate. But on the date of interview, if he can produce the certificate, he would
get the benefit.
Yes.
He will get the benefit of reservation.
That is my instruction. So it is not a question of if and but, not subject to Lordship's kind consideration. তোরা কবে পেয়েছিলি?
আমরা তারপরে
All right, yes.
ডেটটা কবে?
May I just address the court on the logic which has fallen at last? Why this crucial date? In several judgments, Roshvi has said crucial date. Why this crucial date? Say, for instance, candidate knows what are the criteria for issuance of the EWS certificate. On the date of application, he takes a chance, applies as a UWS candidate, and prepares himself so that in the subsequent years, when the EWS certificate is issued, his family comes within the conformity with the EWS certificate. Say for instance,
Yes, say for instance, I didn't get it.
point is, as of today, what are the criterias? Criterias are 8 lakhs is the income, 5 acres of residential, 5 acres of agricultural land. They should not have residential flats of 1,000 square feet, residential plot of 100 square yards, residential plot of 2. These are the criterias. Now, say for instance, in 2022, 2023, being the appropriate year prior to the issuance of the recruitment process, the candidate is not satisfied. Candidate takes a chance, applies under EWS category. Lordship has given one logic, I am giving another logic. Why this crucial date is very important. Candidate applies under EWS category. Thereafter, consciously makes his family ready so that in the subsequent financial years, get rid of the land.
That is a lot of makeup to be done.
So therefore, my lord, these things have to be taken into account. These things have to be, say for instance, a person is being only rejected EWS category certificate because he knows that he is having 100 square yards of land. He gets rid of that. In the subsequent year, he is eligible. So with that certificate,
all candidates,
might be.
Candidates
When we are considering
if there
hypothesis,
are particular instances, then that is different.
when
But
we are,
then in general,
this is why the Supreme Court has in all occasions said the crucial date. Kindly comes again to Divya. Kindly comes again to, my lord, paragraph 51 of Divya. That is 2024 1 SCC 448. It is also very settled, very well settled, that if there are relevant rules which prescribe the date on which the eligibility should be possessed, those rules will prevail. In this case, it is not there. In SSC, they say it was there. In absence of the rules at any other date prescribed in the prospectus advertisement for determining of the eligibility, there is a judicial chorus holding that it will be the last date of submission of the application. And crucial date, that is also mentioned in the circular, the FAQ, the judgment of the Supreme Court is last date. So that is why the judicial chorus. So there is no scope of arguments. Now what they are saying, the argument which has been advanced by the learned government pleader is that date of interview is unheard of. 2026 they will say, if they take the date of interview subsequently, then subsequently. This is totally contrary to that they have said in the paragraph 11. It's contrary to the principles. Kindly comes to paragraph 11, which has been placed, paragraph 11, Lordship may not open, that any candidate who applied under EWS category has received reservation benefits from 30th 11 2025. This is admission that they have committed an error. Now paragraph 3 has been relied upon, my lord. Now kindly, my lord, another, yes. Now, my lord, page 48 and 50, lordship it has fallen from your lordship. There has been no adjudication in those matters, so therefore not relevant. Lordship has taken care of the vertical, the horizontal reservations, the social reservations of caste in your lordship's judgment in Kamala, in the second last paragraph, I think. Lordship may kindly see, lordship has dealt with this issue, my lord, in your lordship's judgment. Now, my lord, the arguments which has been advanced by the proposed private respondents, paragraph can 2, my lord, no challenge has been given to the recruitment notification. Now, may I just come back to the recruitment notification? Why will I challenge, my lord? There was, my lord, a clarity in the recruitment notification that at best, my lord, the certificates issued by the competent authority valid for the year 2023-2024 or onwards, within bracket, issued for financial year 2022-2023 or onwards. So therefore, it was, my lord, there that it cannot be beyond 2024. So therefore, it has not been issued. And thereafter, my lord, what has been challenged? Page 57 has been challenged. Page 57, it was issued on 20th January 2026. The writ petition has been affirmed on 5th February 2026, within 5-7 days.
No, this recruitment notice was published on 5th of March 2024.
Yes.
You filed writ petition in February 2026.
Challenging the memo at page 57. Can you see page 57? Onwards.
Interview.
Onwards. They kindly see they have altered the criteria. That is the challenge.
23-24 onwards was there.
It was 2022.
22-23 and the page 57 is?
Is only 2023-2024 or onwards. So that is the challenge. Page 57. And compares with the recruitment notification.
And tell me one thing, State, I would like to hear from you. How can the EWS certificate for the year 23-24 issued in 2026? How can that be? Can it be issued? And issued for the financial year 22-23.
2021.
No, page 15 says 22-23.
Yes.
Valid. Issued for the financial year 22-23. Valid for 23-24. How can this certificate be issued in January 26? Tell me. Can it be done?
That is why the closing date. Closing date, closing date, closing date. That is the only chorus. Cannot be beyond the closing date. The last judgment which has been relied upon ideally, paragraph 18, I have drawn your lordship's kind attention.
Last judgment.
Last judgment, that is 2024 2 SCC.
Yes.
Union of India versus Gaurav Singh, which has been relied upon by in the FAQ also.
Yes, yes.
Technical illegal certificate by such and such cannot be equated with an income and asset certificates in respect of different financial year when the income and assets for the particular financial year prior to the year of submission of the application goes to the root of the eligibility of the candidate to qualify in EWS. Primarily, it should be idea is prior. If you are EWS, you can satisfy and go and acquire the eligibility. Now, my lord, the respondent is well aware. That's, my lord, I'll just skip over. And the persons who obtained the certificates, subsequently they have been, my lord, this is totally applicable in respect of the proposed private respondents. However, in case of the respondent, may I just place my paragraph 22 in its entirety?
Yes.
The case of the respondent petitioner number 3, the income and asset certificate which had initially been questioned as having been issued by an authority not competent was later accepted, and it was found that the authority issuing the certificate was in fact competent. The certificate of the respondent petitioner number 1 was also accepted, and there was no discrepancy in either the date of issuance of the certificate. It was just that the seal had been stamped without the full name of the officer concerned, and that was accepted as an error not attributable to the candidate concerned. However, in case of writ petitioners 2 and 4, the certificates are in respect of subsequent financial years as observed. In our considered opinion, the High Court fell in error in directing that all the respondent petitioners be treated as EWS, even though the respondent writ petitioners 2 and 4 were ineligible in the terms of notification in the such and such relating to the later financial year. So they are saying 2026.
Assuming that the corrigendum or the notice that you are challenging is
Yes.
incorrect,
Yes, yes.
you do not qualify for the interview.
I do not qualify for the interview, yes.
What benefit do you get?
I have.
They are out. If they are out,
We are all there.
how can you
As of
not in the interview?
No,
Where
we
you
participated. Yes, yes. We
you
participated in
no interview notices were issued to you also?
preliminary. Accept. Valid for subsequently হয়েছে. Well, this subsequent, I think we have participated in the interview. This was subsequently interviews took place. This is my
Take instruction, yes.
Certificates which were produced on the date of interview before they were selected. The certificate was obtained by the candidate, more than 1,700 candidates, much prior to that. Not that they received the or obtained the certificate in the year 2023. This is not true. They had the certificate with them. On the date of interview, they produced.
Are you sure? Because the private respondent says that all certificates were issued after the closing date of the application.
Yes. That's my certificate. Can you see my certificate?
So after,
Can you see? Can you see only one thing I'd like to show?
No, one minute. GP sir, you please produce the relevant memos and the circulars, whatever, relating to issuance of EWS certificate.
That is
The period, what is the circular rule that you follow? Because DOPT has been produced.
On the closing date of application, and not on the date of interview. Between if the candidate procures a certificate.
Forget that. In general, not relating to this matter. EWS certificates are issued for which year, valid for which year? What is the principle that you follow? Please bring. All right. So that we can understand whether there is any error in the advertisement itself or not. You say in the advertisement at page 15 that the certificate will be issued by the competent authority valid for the year 23-24 or onwards. Issued for the financial year 22-23 or onwards. And then comes
page 57,
which says that the it should be valid. The validity period of the certificate will be 23 and 24 and onwards.
Yes.
No, but then page 57 is in line with page 15. Is in line. There is no difference.
There is no difference. That is what I'm trying to show your lordship.
No, I do not think there is any difference, but I just want to know how can a certificate which is issued in January 2026 on the date of the interview which you are accepting can be valid for the can be issued for the financial year 22-23. Back date. It should not be done.
No, my lord. That is not the case. Kindly see page 25.
1 minute. Let
Let
the court also try to understand and let the GP also try to make it clear. The advertisement is very clear. It should be issued for the financial year 22-23.
or onwards. Thereafter again.
Year is starting from a particular date, ending on a particular date. It's a specified year.
How can it be issued after 2 years?
Exactly. Absolutely. How can this be issued after 2 years? What is the system that you follow?
That is a different
Because
department also.
yes, because why I put this question to you, because you have referred to pages 48 and 50, another honorable court. That was the reason what I can understand. Even I had cases when SSC matters were going on, that applications were made prior. The certificates are issued long after. And the candidate should not suffer for this.
Take instruction to that effect, but this should be properly answered by my lord. Because
They cannot. How will they answer?
Now, my lord,
When did you apply and when did you get the certificate?
That is, I'm produced.
You have produced. Please show when did you apply and when did you
But
get?
that is, I've just handed over to your lordship.
Oh, this one.
Yes.
When was the application made?
It was issued on 4th of October 2020.
No, this is issued on 29th of October.
29th of October.
29th of October 2024. When did you apply?
That I can't say.
I want to know when did you
I
apply.
come. But only one thing,
That means
subject
you
to your
make application even after the closing period of the.
that is the lordship, the given permission is given by the recruitment notification itself.
Right.
Kindly see page 30.
Now, another thing I would like to know whether the recruitment notice is hit by whatever is mentioned by the Honorable Supreme Court in Gaurav Singh, in Divya, and the DOPT is issued by the Union of India.
Even the notification says at the time of interview, I have the authority, I have the option.
Whether that notification can be said to be valid in the eye of law.
But that, well, kindly see, that can be challenged by a person who is failed all along.
All right, doesn't matter. It has come to the court.
That's true. There is a court of equity. I know.
Now,
But
another
kindly see on page
instruction,
33.
another
I only
instruction.
think that
Kindly sees the bona fide of the petitioners. We have challenged that particular notification prior to the participation in the interview. We have participated in the interview.
Prior to sitting in the examination.
Yes, prior to sitting in the examination. Subsequently interview, we have participated and the learned GP is not instructed. They have published the results also.
No.
They have published the results.
No.
I want to know that this was published in 5th of March 2024.
5th of March, recruitment notice.
Recruitment notice.
Yes.
You knew. You
Challenges.
knew.
Challenges. The subsequent page 57.
It
Page
is the same
57.
thing.
Page 57 is totally contrary.
No.
Kindly compare.
How is it?
Kindly compare.
Yes, please show.
Issued by the competent authority, valid for the year 2023-24 or onwards, full stop would have been okay. It continues.
Page 57, you are reading?
No, 15. Acha, okay, I'll come to page 57. Yes, kindly keeps page 57 open.
Yes, 57 and 15, we read it parallelly.
Yes. 15 is, it goes on to say, issued for financial year 2022
No, prior there.
Yes,
issued
that is
by
why.
the competent authority valid. So the validity period has
For
to be
2023-2024
or
onward within bracket.
within bracket issued for the financial year
2022-2023 or onwards. So it will be taking to 2024.
Yes.
Kindly now sees page 57.
Yes.
Only 2023-2024 or on.
Yes, it's valid for the year. Valid for the year. It is also mentioned just the line.
This is 2023-2024 or onwards takes us to 2026. But the notification, recruitment notification would be, my lord, expiring its scope in 2024.
No.
Be closing at 2024.
Where from? It doesn't say so. It is your interpretation.
My lord kindly sees here 2023-2024 or onwards.
1 minute.
Issued.
Valid for the year. Issued by the competent authority valid. So the validity period should be 2023-24 or onwards.
Issued for the financial year 2022-2023 or onwards. So 2022-2023 or onwards.
We do not go to the issuance. Suppose we do not go to the issuance.
Had it
part.
been full stop here, then I don't have a case.
Assuming we do not go to the issuance part, whenever it is issued. 26, as has been said by the GP, it has been issued in 26. But the validity period should be for the year 23-24 or onwards. And now what does this mean?
If that be so,
and this is
22-23 or onward means it has to be remitted in 2024 or the last day.
Your interpretation.
That is also the Supreme Court.
Yes, that the GP will
crucial date.
Answer.
Crucial date.
That the GP will answer, but I do not see much difference between 15 and 57.
Crucial date, because otherwise, well, the object is not achieved.
Validity period is 2020 through 24 onwards, 23, 24 onwards.
Otherwise, my lord, the
Here also 23, 24 validity periods and
onwards, quote unquote, issue
it is onwards.
issued for the
right?
financial year.
How can the income certificate which is valid for the year 23, 24
or onwards
be
issued for financial year 2023-2024?
But kindly see now page 25. Kindly see page 25. My lord, I.
Yes.
Why I am submitting. But candidates qualify for interview must submit their caste certificate, caste or caste category certificate to change his her category form. Undeserved PWS. Even I appeared as an undeserved candidate at the time of interview. I have been given authority to change my lordship the category.
This is absolutely contrary to what the Supreme Court has laid.
But that is not challenged before your lordship. They have accepted, they have appeared.
It can be taken that this has been done to give benefit to a particular set of candidates. Absolutely.
Not only EWS, in every cases, SC, ST, OBC,
So that's
exempted.
the crucial.
They know on the first
Good,
day
bad,
itself.
indifferent, any certificate which a candidate is having prior to the date of closing is valid. That is the only interpretation that can be done.
What the state has done is
Ad
absolutely
infinitum.
contrary. Absolutely contrary to the law laid down by the Supreme Court.
What will say? This is the reason. That is why we appeared and we have selected up to the interview. And they knows very well in the first date.
And the matter is going to go up to the Supreme Court and the all recruitment processes. All the candidates, their life gets jeopardized.
In any case, this recruitment process is difficult. Subsequent matters are also there, I'll show. That's a different point.
That I do not know.
It's a different point. That's a different.
Please come.
Sir, kindly add him at the party.
I'll add you.
Then can one is also supporting us, my lord, kindly adds also.
So can one look quick.
Can one has been filed by whom?
The supporting. He is the advocate.
Supporting means y'all are challenging.
No.
Same thing.
We are supporting they are supporting us.
That means they are challenging the private respondents who want to be added.
Yes. Taking part in the selection process. Now they start giving up.
You are the state. You are the state. Right now, you are not for any private party. So you have to defend the state as to how the terms and conditions of the recruitment notice is in line with the Supreme Court directives and the DOPT circular issued by the Union of India.
State.
No, it happens. You have this is the transition period. You have you have to.
There's a notification of 1923 issued by the government, state government also regarding EWS.
The petitioners.
Even the supporting candidates have secured more than marks of EWS.
The petitioners participated in a recruitment process pursuant to a recruitment notice, a recruitment process for the post of constables in West Bengal Police -2024. In response to a recruitment notice published by the West Bengal Police Recruitment Board on 5th of March 2024. The challenge in particular is with regard to reservation of the economically weaker section candidates. Stop. As per the recruitment notice, the candidates seeking reservation under EWS category if shortlisted for interview, must produce income and asset certificate issued by the competent authority, valid for the year 2023-2024 or onwards. Bracket open. Issued for the financial year 2022-2023 or onwards. Bracket close. During checking of testimonials on the date of interview. A notice was paragraph. A notice was published by the recruitment board on 20th January 2026. Mentioned that the income and asset certificate for candidates belonging to EWS category must be valid for the year 2023-2024. Stuff. A corrigendum was issued by the board on the same date, that is 20th January 2026, mentioning that corrigendum notice can you please tell me which notice was issued earlier, 57 or 58?
58 was issued earlier. Thereafter changed to 57.
How do you know where from does it appear?
They have said so in their affidavit.
In their affidavit. But from looking at the notices, can you identify which was?
No, nothing. Cannot be identified. They have admitted in their report. Reporte paragraph ta kotha bol?
হ্যাঁ হ্যাঁ রিপোর্টে বলেছে তারা প্যারাগ্রাফ
Erroneously এটা বলেছে।
and then and their withdraw.
Were issued by the board on the same date. A notice now, two notices were issued by the board on 20th January 2026, wherein paragraph
13,
small e,
it is
has
further
been
clarified.
mentioned in one of the notices that income and asset certificate for candidates belongs to EWS within bracket EWS. Na, ageta likhben economically weaker section, tarpor EWS. Valid for the year 2023-2024 or onwards. And in the other, paragraph 3 reads as income and asset certificate for candidates belongs to for economically weaker section within bracket EWS, valid for the year 2023-2024. Stop paragraph. Specific case made out by the petitioners is that petitioner bodhoy eka ache.
Only one.
Petitioner one. Petitioner is that the date for production of the reservation certificate should be a fixed one. Stop. The same would not remain open-ended. Stop. Within single quotes, crucial date is very important for the purpose of obtaining benefit under EWS category. Stop. In support of such submission, reliance has been made by the petitioner in the judgment delivered by the Honorable Supreme Court in the matter of Union Public Service Commission versus Gaurav Singh and others. reported in 2024 to SCC 605, comma, Divya versus Union of India and others, 2024, 1 SCC 448.
One thing, my lord.
Stop. Reliance has also been placed on the judgment delivered by this bench on 8th December 2025 in WPA 24256 of 2025, Can 1 of 2025. Komalakanto Maiti and others versus State of West Bengal and others. Where is the DOPT circular you showed me?
That is in the exception.
Acha.
But one, my lord, may I take a opposition to the can, my lord? Because
Wait,
it is not
one
being-
minute,
Acha,
1 minute, just wait. Acha. The frequently asked questions on reservation to EWS in posts under the central government answered by the Ministry of Personnel, Public Grievances and Pensions, Department of Personnel and Training, Government of India, dated 19th September 2022, annexed to the exception filed by the petitioner to the report filed by the state in support of the crucial date for income and asset certificate has also been relied upon. Stop. Submission is that the recruiting authority ought not to rely upon any certificate which has been issued after the last date of submission of the application seeking recruitment. ঠিক আছে? আর একদম উপরে লিখবেন তো, report in the form of affidavit on behalf of the state respondents and the exception thereto filed by the petitioner filed in court be written with the records. Acha, an application seeking addition of party, which is the supporting one, Can 1?
Supporting can.
Can 1 has been filed by applicants who are supporting the stand of the petitioner. Stop. Can 2 has been filed seeking addition of party opposing the stand of the petitioner. Stop. Paragraph. The applicants in Can 2 rely upon financial certificates issued in their favor after the last date of submission of the application. Stop. According to the applicants, the recruitment notice permits filing of the certificates which have been issued in the year 2023-24 onwards. Stop. The applicants submit that the recruitment notice is not under challenge. Stop. The petitioners have approached this court long after they were declared unsuccessful in the written examination and were ineligible to participate in the interview process. Stop. The
I have satisfied.
learned government pleader relies upon the report affirmed by the Deputy Superintendent of Police, bracket open Administration and Law, West Bengal Police Recruitment Board, and submits that the recruitment is being conducted strictly in accordance with the recruitment notice. Paragraph. Though the applicants opposing the stand of the petitioner have been heard, but formal order for their addition has not been passed till date. Stop. Paragraph. The writ petitioner intends to file an opposition to the application seeking addition of party. Stop. The for proper adjudication of the instant list, the petitioner is permitted to file an opposition to the application Can 2 of 2026
1 week.
by 3rd of July. It will be open for the applicants to file an exception thereto by 10th July. Stop. The state respondents are directed to file a further report affirmed by an affidavit disclosing the circulars, government orders, rules and regulations followed by the state for the purpose of issuance of income and asset certificate in respect of an applicant. Stop. The report shall the learned government pleader shall address the court on the adjourned date as to whether the recruitment notice is in line with the law laid down by the Honorable Supreme Court in the matter of Divya within brackets Supra and Gaurav Singh within brackets Supra. Particularly with regard to the last date of consideration of the income and asset certificate. Whether the same, whether the period for which the certificate is to be taken into consideration can be left open-ended, and whether any certificate issued after the crucial date can be taken into consideration for ascertaining the eligibility of a candidate seeking reservation on financial ground. Released for further consideration on 20th July 20.
This kindly makes it part hard. Lordship has heard entirely, given nearly 2 hours.
On principle, I do not keep matters part hard. Why I tell you? Because
no one will object.
It is not a question of objecting. If you want the matter to be heard by this bench, I have passed a fairly detailed order. Seek a request for assignment so that it can be heard. Otherwise,
uncertain times,
somebody will say the court has got personal interest, which the court simply doesn't have.
This is previously this was going on. Thereafter,
that is the reason it has been stopped. And
thereafter again revived.
Not revived.
There was a circular saying that moment the determination changes, parthars will be released. Yes. Thereafter, it has again been brought back, saying that will be onerous for the litigant public, so that, my lord,
But there is no order from the Chief Justice which permits the court to mark it as part-heard.
oh, there is.
Show me.
There is.
If you can show me, then I can. Otherwise,
monthly
because my officers have said, take the monthly list.
Previously, that is an order of Supreme Court, and thereafter it has been.
Show me if there is some provision, then I can treat it as part-heard. Otherwise, no. এটা item 20 তে হবে। আচ্ছা, আরেকটা জিনিস লিখুন তো।
I'll show the
The applicants in can 2 are directed to file an affidavit clearly indicating the dates on which applications were made for obtaining the certificate, income and asset certificate, and the dates on which the certificates were issued in their favor by the competent authority. Addition of party, I have passed an order.
Yes, ma'am.
File an affidavit disclosing the date when you made the application and the date when you got the certificate. Followed it.
Well, he's finding it out. Next matter.
Let him find it out. I am here. Do not worry. In case you can show, then I can mark it as
My
part.
lord, I have the judgment also. I'll come.
I'll show.
Not the judgment.
mobile
You, if you can show me, if you can show me, not the judgment. With the judgment, you can seek assignment.
Oh.
But not marking as part-heard. It has to come from the chief.
And my lord, one, your lordship has recorded that
can't allow.
he didn't qualify.
Can one to allow? Can one is allowed? Can to allow হবে না? Let the opposition.
My lord,
be heard.
lordship has recorded that we didn't qualify. Fact is, we qualified and our names are there. We have secured marks
That
over
is the applicants, not you personally.
I have also. I have also.
Chakraborty
Same,
also.
Yes.
আচ্ছা, ঠিক
That
আছে.
is
Doesn't
why.
matter. It is his submission.
Yes.
At the final hearing, we can always.
I will, my lord, point it out on the next.
All right.
Let the order comes thereafter.
Another dispute will cropped up regarding OBCA or OBCP.
Second.
That is.
I'll address that.
Another set of writ petition will come.
Another set of writ petition is here. Next.
এটাকে এখানে একটু দেবেন তো। এইটা ফেরত দিয়ে দিন। Applicants.
ঠিক আছে।
বাঁদিকে, yes. এটাকে রাখবেন। Yes. Are you sure you'll not be required in other matters?
I shall come.
All right.
Yes, well, this is having regard to the ratio decision in the case of High Court on such.
This is 2013, 2012. Come after that.
All part na er poreও আছে. এর পরে আছে.
This is the old one.
Yes. Thereafter, Supreme Court is there.
I have sought for information from my officers whether I can do it or not, and I was told that you cannot.
No. This is, my lord,
No, sorry.
Powers of the court, my lord. Administrative notifications will not guide your lordship while exercising judicial.
1 minute. This is item 20. What is 21?
21 and 22 different matters with regard to the
Different
same
matters.
recruitment process. Here, my lord, they have committed gross error.
With হবে না। ভুল হয়ে গেছে।
Here, my lord, they have committed gross error. Kindly takes up Chandan Dhara.
State is appearing?
Yes.
The GP will be there?
Same. Kindly takes up Chandan Dhara, WPA 7318 of 2026, which is the next 22, I think.
Yes, item 22.
Yes. Well, here, our contention is that we belong to NVF and Home Guard. The recruitment ballot rules reserves 15% for the Home Guard and NVFs, 15% for the civic volunteers, village police, which is a horizontal reservation.
বোর্ড কাজ করছে না, ওই বাজ পড়ছিল তো সেই জন্য। Doesn't matter here. Yes.
My lord, horizontal reservations are there in respect of NVF and Home Guard. Horizontal reservations are there in respect of civic volunteers and village police. Now, my lord, we are falling within that category. We participated in the recruitment process. 20-21. Now, my lord, the recruitment process, my lord, horizon for the post reserved for, my lord, the in horizontal reservations were 1800. In the category of Home Guard and
Which page
NV,
Yes.
this is the recruitment rules.
Hmm.
Now kindly comes to
Where is the reservation?
6,
6.
51 page.
Yes, page 51.
Clause A is the social reservation.
Hmm.
That is the vertical reservation falling out of 1976 Act and 2012 Act. B is horizontal reservation. 30% post will be reserved for exempted category candidates in terms of extant rules. We are not concerned. C, 15% post will be reserved for Home Guards and National Volunteer Force personnel who have completed 3 years of service as on first date of January of 2020 year advertisement recruitment. And D, 15% post will be reserved for civic volunteers and civic police volunteers who have completed 3 years of service on the first day of such and such. F, kindly sees reservations of post in sub-rule B, C, D, E will be horizontal in nature. Now, my lord, kindly comes to recruitment notification again at page 55. The breakup is there. Lordship would see unreserved, that is unreserved NVF and Home Guard, and unreserved civic volunteers and civic volunteers and civic village police volunteers. Lordship has seen 960. So this is 960 is 15%. So these posts were reserved. This category of reservation is in every category. Is horizontal reservation is in every vertical reservation. Vertical reservations are SC, ST, OBC A and B. Now, my lord, these horizontal reservations are there also in SC and also in ST. In respect of SC, it would be 360, and my lord, in respect of ST, it will be 120. OBC, I am not, my lord, agitating now because there are no OBC candidates, though there is a huge confusion now. Now, my lord, subsequently, my lord, we participated in the recruitment process, and my lord, they didn't publish any notice, any particulars with regard to what are the marks which have been obtained by the candidates who have been found to be eligible to participate in the subsequent process. They had published a, my lord, non-transparent, my lord, chart at which is a sample of which is at page 89. আমাদেরকে কিসে পার্টিসিপেট করতে দিয়েছে? পার্টিসিপেট করতে দেন, exactly. Now kindly see, this 89 was challenged by us in the previous round of litigation. The judgment whereof starts from page 105. I will not trouble your lordship with the entire judgment. Because our grievance, first 1 or 2 paragraphs, my lord, may I just, so that the facts are there. In terms of order dated such as the matter is heard, the pursuant to the recruitment notification dated for recruitment in the post of constable in West Bengal Police, written test was conducted following West Bengal such and such. Based on written test, 60,000 number of candidates were shortlisted by the concerned recruitment authority for conducting physical measurement test, for short PMT and physical efficiency test and viability. List containing shortlisted candidate based on written test is bereft of necessary particulars, that is marks obtained by the respective candidates in written examination and categories of the candidates. Question arises for the consideration is whether publication of the aforesaid list without indicating marks obtained by the respective candidates in written examination and the categories of the candidates permissible or not. Petitioners participated in the written test, being part of the selection process in terms of such and such. Petitioners belongs to different categories of unreserved, scheduled caste, such and such. Thereafter, my contention kindly skips over. One copy has been given, page 1088, paragraph 13 onwards. Kindly see, this was not annexed in the main writ petition, so therefore another copy of this judgment was given to your lordship.
108.
Paragraph 13 of the judgment is not there. Internal page 5 of the judgment, I think it is not there.
not
So therefore
there.
another copy of the judgment was given. If your lordship may kindly finds out from your lordship's records. I'm very sorry for the inconvenience. Lordship may-
Battery, yes. Got it.
Yes, paragraph 5.
Hmm.
In the aforesaid conspicuous and in order to maintain transparency in the selection process for the post of constables in West Bengal Police, which is being conducted pursuant to recruitment notifications and such, respondent authorities are directed to publish list of selected candidates for holding PMT and PET, disclosing marks awarded to those candidates in written examination and their respective categories as detailed in the recruitment notification dated such and such. Concerned respondents authority are directed to public list in terms of such and such 7 days. Now, thereafter, for the first time, this list at 111 was published. Now, from this list, I have not annexed my lord 60,000, but I have annexed a sample. From this list, it would appear that the cutoff marks were calculated so that they can proceed to determine the horizontal vacancies, which is the stand which has been taken by them in their exception in the report. Now, from that it will appear the analysis of this is at page 121, from where it will appear that, my lord, only an analysis at page 123. Eta ki? Oh, yes. Yes. This is page 121 are the names of the only 55 candidates who have been allowed to go in the next level of recruitment. And from the analysis, NVF. And, my lord, in where the posts are 1800, only 55 has been allowed to go to the next level. So therefore, the other parts, 1800 less 55, the entire thing has been shifted to unreserved, saying their contention is that we have not been able to clear the cutoff. But the process that they have followed is contrary to the Supreme Court judgment, which I'll show. Kindly comes to page 123. This is the analysis which we have prepared, my lord. Kindly sees UR seats is 1200. Candidates in the list is 7,127. That is into 5. They have subsequently, my lord, said this is more than 1:5. Why this has happened? Because kindly sees in respect of UR Home Guard NVA, the seats were 960. As I have indicated to your lordship, they have only allowed 6 candidates because of the cutoff procedure that they have adopted, which I am criticizing and saying is contrary to the judgment of the Honorable Supreme Court, which I'll show. But for that, the factual, my lord, basis is that next is UR civic volunteers, the list, the seats were 960, only 61 has qualified. Simultaneously, SC Home Guards and NVA, the seats were 360, only 12 has qualified. And, my lord, SC civic volunteers, the seats were 360, 271 has qualified. ST Home Guards stroke NVA, 120 seats were there, only 9 have qualified. ST Civic Volunteers, 120 candidates were there, only 73 has qualified. Now, my lord, they have converted these sports into unreserved category, which they can do. Horizontal reservation, it can be done. in my humble submission, the procedure that they have followed, as they have stated in the affidavit in opposition, kindly takes up their affidavit in opposition at paragraph L.
Where is the opposition? চন্দন ধারা
চন্দন ধারা
দেখুন তো দিয়েছে কি আই ডোন্ট সি
আর একটা অপোজিশনের কপি আছে কেন
ওর ভেতরে ঢুকে গেছে কি
দেন আসো এমনি দেন একটা
না
কপি দেন
মন্টু মান্না not here.
I have a copy if your lordship wants.
Today because I don't know whether it was filed by Asha, panel actually it was.
It has been given.
Still panel advocates. And I think it's not filed. I filed my report for option.
কবে আসছো সরকার
It has not been filed because had it been filed then it would have been recorded in the
20th
audit.
May এটা দিয়েছে
Then I have a copy of the same.
When was it affirmed?
20th April 2026.
Right. 20th April?
Yes. Kindly
Last, it was taken up on 20th of May.
20th April.
Wait, in that case, let me see once.
This is the copy of the opposition.
Wait. No, opposition to nahi. Exception will be prepared. I have the instruction that was there.
That
but
has
not
been, my lord.
the opposition.
That has been, my lord.
No, opposition is not here.
This is the opposition.
Dekhi. Check up whether it has been filed in the department or not. That also you please check.
It can be taken from the erstwhile learned advocate, Mr. Shapon Dotto was being assisted by that.
Thing is, once you are depaneled, you are not permitted to keep copies. You are to hand it over to the GP's office.
Must have been done.
So,
it has been kept in the, my lord, bunch. Now it will
the
not.
bundle must be there. Which page are you relying upon?
Now, my lord, paragraph L.
At page?
Page 11.
11. All right.
The West Bengal Police Recruitment Board has Muntu one. Oh, lordship, next matter, I think opposition has been filed. Any case, may I just proceed?
Yes, Montu
Yes.
opposition is here on
Yes.
record.
Now, my lord, may I just proceed this? The West Bengal, same copy paste. The West Bengal Police Recruitment Board has decided to keep the cutoff of score of candidates to be considered under horizontal category for each vertical category 6.5 marks, less than the cutoff of the score of its normal vertical category for the shortlisting them for physical measurement test and physical efficiency test, so that all horizontal category candidates are treated as equal within the vertical category. The West Bengal Police Recruitment Board decided to call approximately 5 times the total vacancy under each vertical category. This is very important. 1.5. This is not the any recruitment rules. They have admitted. Good that they have admitted. Times of the total vacancy under the vertical category for physical measurement test and physical efficiency test, according to the board, had fixed a cutoff of score for your category in such a way that it is cutoff score remained higher than the cutoff score of the other vertical reserved categories. Then the board tried to accommodate one horizontal category candidate under your category, said by removing the last selected pure your category candidate from the list, and so on, keeping his stroke her and their cutoff marks in such a way that it remains higher than the other vertical reserve category. The reason behind was that your horizontal category candidates is firstly a your candidate, and the candidate score must be greater than the cutoff of the other vertical category candidates, but would be less than normal your category candidate. Else, horizontal vacancies of all categories will be different set and would not be compartmentalized vacancy. This approach is totally contrary to the Supreme Court. The Supreme Court has specifically laid down why I am saying so. In all recruitment process, none of the Saurabh Jadhav. Kindly sees 2021 4 SCC 542. I will, my lord, straight draw your lordship's kind attention to internal page 580 without any, my lord, discussions, everything, my lord, so that it is laid down there. I'll show. Other things are there. If required, I'll show. Here, my lord, it was being discussed horizontal, my lord, reservations in respect of women. 508 kindly sees High Court such and such for the figure for further guidance of the state government. We would like to explain the proper and correct method of implementing horizontal reservation for women in a more lucid manner. Proper and correct method of implementing horizontal reservation for women. There is an asterisk. I have marked that asterisk. Kindly compare this asterisk with the end. Kindly see end here. This method has been expressly affirmed by the Supreme Court in paragraph 43 above. So therefore, let us for the moment not go into the reasons of affirmation. Let us proceed on the basis that this is the formula which has been affirmed by the Honorable Supreme Court. Now kindly see what is the formula. Number of posts available for recruitment. This is the hypothetical number which has been taken. In our case, this number 100 will be 11,749. Social reservation 49%. In our case, it is 55%. Open category, it has been construed to be 51%. In our case, the figures are different. In our case, I have added up. Kindly takes me for this point that I have added up. The number would be 6461. And thereafter, scheduled caste, scheduled tribe, such and such. Horizontal reservations for women 33%. The number is set out. Now kindly see how it has to be done. Step 1. Draw a list of 100 candidates. Usually a list of more than 100 candidates is prepared so that there is no shortfall of appointees when some candidates do not join after qualifying to be selected in order of merit. This list will contain candidates belonging to all the aforesaid categories. So therefore, this is on merit, simply on merit. And in this case, 100, they have said 1.5. So therefore, this will be 500 if the recruitment is for 100 posts. This will be 5 times 11,749. This is the 66,000 or something. This is the first. So first is merit, only merit, everything. Step 2. From the aforesaid step 1 list, draw up a list of the first 51 candidates to be filled up on OC quota open category. So this is the first open category. On the basis of, in this case, this will be 6,461. Let us proceed on the basis of 100. From the aforesaid step 1 list, draw up a list of first 51 candidates to fill up the OC quota 51 on the basis of merit. This list of 51 candidates may include the candidates belonging to SC, ST and ACB. That is, well, the SCBE is socially and educationally backward classes. That is backward classes. This is own merit. Because these may be included because of the own merit rule. If the person is getting more marks, best marks. So every category is included. May I just again place? From the aforesaid step 1 list, draw up a list of the first 51 candidates to fill up the OC quota on the basis of merit. This list of 51 candidates may include candidates belonging to SC, ST and EBC. Step 3, very important, do a check of horizontal reservation in OC quota. In step 2 of OC category, if there are 17 women, category doesn't matter because horizontal, women's quota of 33 is fulfilled, nothing more is to be done. So if 33% of the women qualify in merit, then nothing has to be done. Finish. 33% fulfilled. If there is a shortfall of women, say only 10 women are available in step 2 list of OC category, 7 more women have to be added. The way to do this is to first delete the last 7 male candidates of the step 2 list. Thereafter, go down the step 1 list, that is merit list, after item number 51, because 51 was the number of persons, and pick the first 7 women category, does not matter. As soon as 7 such women from the step 1 list are found, they are to be brought up and added to step 2 list to make up for the shortfall of 7 women. Now the 33 quota of OC women is fulfilled, list of OC category is locked, step 2 list become final. So first is merit. If in merit 15% of the civic volunteers, 15% of the NVA, 15% comes, then finish, nothing has to be done. If it is not there, then they have to find out. Go down the list and find out where is the civic volunteer, where is the person who will be brought up in the list and would be added in the last of the list. Now, step 4. Yes, that marks will be cut off. Step 4. Move to SC. Now, this is in respect of reserved, unreserved civic volunteers and civic volunteers, NVA, village police, all unreserved. Now is SC. Move to SC. From step 1 list, after item number 51, item number 51 would be read as 6,461 candidates. Draw up a list of 12 SC candidates, male or female. These 12 will also include all male SC candidates who got deleted from step 2 list to make up for the shortfall of women. Because they were meritorious and qualified, but they were not SC, so therefore they were deleted. They were SC, but they were deleted. They had qualified and gone to step 1 list on the basis of own merit, but they got deleted to accommodate women. So now they will be again now considered. Step 5. Do a check for horizontal reservation in the step 4 list of SC. If there are 4 SC women, the quota of 33% is complete, nothing more is to be done. If there is a shortfall of SC women, say only 2 women are available, 2 more women have to be added. Now, where we'll find? The way to do is to first delete the last 2 male SC candidates of the step 4 list, and then to go down the step 1 list after item number 51 and pick up the first 2 SC women. So in the first, it was only women to fill up the 33% woman category. Now, when it is being considered as SC, now in terms of our recruitment will be SC, NVF, civic volunteers and home guards. So 2 more women. I was in
step 5.
Step 5. 2 more. The way to do is to first delete the last 2 male SC candidates of step 4 list and then go down to the step 1 list after item number 51 and pick up the first 2 SC women. As soon as 2 SC women in step 1 list are found, they are to be brought up and added to the step 4 list of SC to make up for the shortfall of SC women. Now 33% of the SC women is fulfilled. List of SC is to be locked. That is SC quota fulfilled. Therefore locked. Step 4 list becomes final. Now again, if 2 SC women cannot be found till the last number in the step 1 list, these 2 vacancies are to be filled up by SC men. So say for instance, in civic volunteers and NVF and everyone, first woman, it is not there, then men. But they have to complete. If in case SC men are also wanting the social reservation quota of SC to be carried forward to the next recruitment rules, there is a rule which permits conversion for SC to OC. Unless there is a rule. In this notification, my lord, there is a rule, they can do it. But they have to go through this to convert. So this they have not done. Step 4 is repeat step 4 and 5 for preparation of ST list. Step 7 is repeat step 4 and 5 in respect of EBC list, that are other backward classes. Now, my lord, this has been upheld. My lord, I will not trouble your lordship in the yes, my lord, 415. My lord, I will not trouble your lordship to go through the entire thing, but this has been upheld. Kindly takes me for this, my lord. And my lord, this particular procedure has admittedly not been followed. They have set up cutoff marks, which is not, that is why, my lord, the persons, they have not even been able to qualify to the next stage. We have been, my lord, what they have done, they have, my lord, shortlisted. Shortlisting is done when there are several more candidates. Shortlisting so that it can. My lord, they have, my lord, used cutoff as an elimination. That they ought not to have done. They should have completed and thereafter completed this. Otherwise, 15% of the, why this 15% reservation is there? And why these NBFC volunteers are there?
In the main recruitment notice, is there any provision for fixing up a cutoff?
Yes, that is there. Cutoff is not pass marks, it is there.
It's for shortlisting.
It's for shortlisting. Kindly see.
Just wait. Let him place his case. Don't make submissions in between.
Yes. Method of recruitment.
Which page do I get?
Yes, madam. Page 62. The first paragraph, the board will have the discretion to fix qualifying marks. Lordship has got here, kindly see here.
Yes.
The board will have discretion to fix qualifying marks in written examination for shortlisting candidates for the next stage of selection. I.e. physical measurement, such and such, such and such, such and such. So it is for shortlisting. It is not elimination. Because of this, we have been eliminated. There are judgments I will not trouble at the fag end of the day.
Will shortlist also not be a matter of elimination? It will be. Shortlisting
When
will
there
be
is
elimination.
excess. Several candidates have come, several, my lord, 15%, even after giving 1:5 ratio of civic volunteers, home guards, if they find that several hundred of candidates, then shortlisting. Stop them. If it goes beyond 1.5 ratio, then it will be stopped. But at the inception, if it is stopped, then the recruitment rules are not being implemented. And this is not in this recruitment process. Well, I have been doing this matter since in SAT, in everything. The recruiting authorities are totally oblivious of this judgment. And this also I have learned in this recruitment when this has arisen. And this will be a judgment if your lordship, my lord, is, if I can, my lord, convince your lordship, which will be followed in subsequent recruitment. Now the government has come, my lord, they are saying several recruitments to be made. This is as a, my lord, this is as a benefit which I am doing to the government subsequently, so that we will be not benefited, but they will know what to do. If your lordship corrects them now.
So it is
We will not get matters, but they will be able to do the recruitment properly.
This is Relating to the reservation policy not being followed.
Yes, horizontal.
Horizontal reservation not being followed.
Yes. Another point will come with which that is with regard to OBC. That is a huge thing that your lordship has to, my lord. Because this recruitment, my lord, as of today, there is no OBC A, OBC B. The judgment passed by the Honorable Justice Prabhupada Chakraborty, authored by the Honorable Justice Mantha, had upheld 77 OBC categories and had struck down the process by which OBC A and OBC B was done. In the last paragraph of the judgment, the Honorable Division Bench was pleased to hold in 2024 that this will not be applicable who have already availed the SCC and who are in service. But these recruitments, now what happened, after that, my lord, several process was initiated for, my lord, recategorization of OBC A, OBC B. That was challenged in the second round of litigation on 17/6/2025. A judgment was passed by the Honorable Justice Prabhupada Chakraborty and the Honorable Justice Mantha, wherein the initiation of process was stayed. The state government went up to the Honorable Supreme Court. The Honorable Supreme Court directed that you may continue. But, my lord,
vacated.
Yes, that stay was there, the stay was vacated. So the process continued. After the new government, my lord, the new government has come and issued notification saying that the previous notifications are all annulled and we will only abide by the judgment which has been passed by the first judgment which has been passed by the Honorable Justice Prabhupada Chakraborty, authored by the Honorable
That
Justice.
means 2011 notification that was.
Yes, 77 OBC.
That
So there will be only OBC, no AB.
Hmm.
So that will also create, in all this recruitment process, there is OBC AB. That will come. Subsequent, some matters will be filed. Saying that these recruitment process, everything has to be redone. It has to be A and B has to be considered as one. That when the
as and when matter
as and when
arises.
matters come, we'll cross. But here, my lord,
Hmm.
my lord, this is, my lord, with regard to, my lord, horizontal reservation. But and admittedly, in the affidavit, they have not followed.
They have not followed.
Not followed because they have
Not followed means
not followed the Supreme Court's process. How to bring, because why this horizontal reservation is given to NVA, to civic volunteers, because we are, my lord, working. Now, my lord, I have also annexed, my lord, documents from where it will appear that NVA, home guards, civic volunteers, village civic volunteers, they run the lower strata of administration. They have at times 24 hours, 18 hours duty is nothing. We have arms training in respect of home guards. We run the administration. Now, my lord, after giving service, if we are, my lord, given to, my lord, compete with these fresh candidates, we will never be able to do. Because fresh candidates are, my lord, pursuing their studies. They are younger. That is why to give this kind of, my lord, leverage, this 15% has been introduced in the recruitment rule itself. But in this manner, my lord, this 15% horizontal reservation is not being implemented. That is, my lord, the grievance. And, my lord, this is not once. Previously, my lord, there was no reservation for civic volunteers. It was entirely home guard and NVF. Now, my lord, at that relevant point of time also, because my lord, these matters are going on, my lord, in the previous recruitment process from 2016 onwards, there they didn't used to publish any, my lord, breakup of marks. I had been able to, my lord, I had occasion to appear where the breakup of marks were not published. This is for the first time breakup of mark has been published, so therefore I can come and agitate these issues before this honorable court. Otherwise, it was totally non-transparent. There are other matters also. So therefore, I, my lord, wanted to, my lord, because I understand they will not be able to, obviously, it is not possible. They have got the brief, say, and they have not been able to sit with the clients. Our clients are unemployed and desperate. Whenever we want, they will come and assist us. In their case, it has to be done in office hours. So therefore, my lord, let them come ready with these points, my lord, and my lord address your lordship. Because this is the issue. It has to be, my lord, decided. Horizontal reservation, my lord. How to, my lord, implement horizontal reservation? My lord, the reply is also, my lord, kindly, my lord, takes on record.
2 for 2 matters?
Chandandhara and my lord.
And 2 for 2 matters?
Yes, 2 matters.
What else you want to?
While seeking one indulgence, since my activity in opposition is not before the action.
I'll give you time to file it.
Let it be the same thing. Otherwise, the entire thing will go out of the
Item number 20 or not, there is an application pending for addition of parties.
By whom?
My application.
Oh,
Yes. Your application, who are you?
Reply copy.
On two applicants, there one is civic volunteer.
Opposition copy আপনাদের.
Are you opposing the petitioner? You are supporting the petitioner?
He is supporting. Reply. একটা করে autograph
The matter relates
একটা করে autograph দিন
to the
এই autograph দে
recruitment to the post of constables in West Bengal Police, 2024. Stop. Grievance of the petitioners is that the principle relating to horizontal reservation has not been followed by the authority. Stop. Reliance has been placed on the judgment delivered by the Honorable Supreme Court in the matter of Saurav Yadav and others versus State of Uttar Pradesh and others. Reported in 2021, 4 SCC 542. Stop. It has been submitted that despite availability of several candidates, the authority, illegally and arbitrarily, fixed a cutoff mark, which is contrary to the principle of reservation as laid down by the Honorable Supreme Court in Saurav Yadav, within brackets Supra. The state respondents rely upon an affidavit in opposition. Stop. It appears that the original copy of the affidavit in opposition has not been filed, though copy of the same was served upon the learned advocate representing the petitioners. Stop. Learned advocate representing the state respondents is directed to file the original affidavit in opposition on the next date of hearing. Stop. Affidavit in reply prepared by the petitioners to the opposition of the state filed in court today be retained with the records. Stop. List the matter for hearing on 1st July. Stop. The 1st of July, I keep it. You please trace out the opposition and file it on the next date. All right. In case it is not there, I'm not recording. Certainly, I'm sure you'll be able to lay your hands upon the original. In case it is not there,
It's a provision for in case it is not available.
In case it is not there, get it reaffirmed. You have copy and file it on the next day. Because first I'm keeping it. Actually, in an application for addition of party by applicants supporting the case of the petitioner has been filed. Can one? For proper adjudication of the instant matter, let the applicants be added as added petitioners in the instant petition. The application for addition of party stands allowed. Department is directed to add the applicants as petitioners, added petitioners in the instant writ petition. ঠিক আছে? এই কপিটা ওনাদেরকে ফেরত দিয়ে দিন। Please take back the photocopy of the affidavit in opposition.
Opposition.
My lord,
আচ্ছা, এবারে এটা হলো চন্দন ধারা। This is চন্দন ধারা, that is item 22. And item 21 has not been placed today.
Same matter, but
List
opposition is
matter.
there. Opposition.
Opposition is there. Reply filed by the petitioners. How many petitioners? And the affidavit of service by the applicants.
Service of application.
Filed in court is taken on record. There is an application for addition of party, can one, of 2026. Oh. Huh? 22 তে ক্যান নেই, তাহলে ক্যান 1টা 21 এতে হবে। যেখানে অ্যাপ্লিকেশন ফর এডিশন অফ পার্টিটা বললাম সেটা হবে এই আইটেম 21 এতে। ওটাকে অ্যালাউ করে দেবেন। ঠিক আছে, লিস্ট অন ফার্স্ট। ওটা কেটে দিলেন কেন? লেখাটা তো থাকবে।
হ্যাঁ বলে দিচ্ছি সাহেব বলা শেষ হোক।
এই তোদের একটা এন্ট্রি মডেল।
হ্যাঁ, ওই লেখাটা যেটা আছে থাকবে, প্লাস স্ক্যানটা এইখানে ঢুকে যাবে।
Abide by that. Notice দিয়ে দিন। My lord, may I?
There is interim order in his matter which says that in our matters also abide by is there, and they have published a notice, I think. একটা notice হয়েছে। Oh, then not triggered. Then not.
No, notice পাঠিয়ে।
Notice দিয়েছে তো।
Notice দিয়েছে।
Then not.
My lord, they
Interim order is there?
Yes. In his matter,
abide by the result of the.
Abide by result, and your lordship was pleased to observe that a notice should be published. That I think has been published.
Yes, it is published. It is published by the court.
Everyone knows.
As the matter is as the matter is being taken up for consideration by the court, accordingly it is made clear that any appointment given in the subject recruitment process during the pendency of the writ petition shall abide by the result of the same.
And my lord, tomorrow I'll come and try to convince your lordship in part heart, both the matters.
All right.
My lord, item number 28.
দুটো ম্যাটারই যাবে।
My lord, item. Sorry.
এটা হচ্ছে
Twenty-eight, 29, 35, 36, and 37. My lord, item number 20 is regarding civic volunteer. Same horizontal reservation is not. I have twofold submission. One is that.
next day I'll hear you.
Yes, my lord.
If the item
But in my matter, my lord.
with করবেন না, with করবেন না।
Is this notice?
I have seen this notice.
Yes.
Keep it with you. I will not want to
My
keep it.
lord, item number 28, 29,
লিখে নিন তো ওখানে।
35, 36, and 37.
হ্যাঁ।
The item number 28, 29 35, 36, and 37. Item number 28 regarding civic volunteer. No, my lord, my lord, why I say it? Because of that, my lord, they ought to came with an affidavit to disclose how many civic volunteers they already inculcated in the system. Because of that's the most important thing. Because they curtailed it in the first stage, that is in written examination. It is on 100 marks examination. First written examination 85 marks. Thereafter PMT,
See,
PET.
the matter has not been heard. The GP is here for the
Yes,
first
yes,
time. He doesn't know
yes.
what it is
No,
about.
no, I am
The
not on
court
that.
also doesn't know what exactly is your grievance.
No, may I address just to one thing, nothing more than. Because in my learned friend matter, they already filed the affidavit by disclosing the fact. In my matter, they not yet filed the report or anything. So
That is the thing. The issue is not there before the court as of now. They don't even know what point is to be addressed.
Okay.
Here the petitioner it has not been taken up. How can direction be passed? The matter which has been taken up, direction was passed and the authority knows exactly what to address.
Yes, madam.
And that is the reason opposition comes when your matter will be taken up.
Yes, yes, madam.
Accordingly,
Yes,
it will be given. পরেরটা ডাকুন কোনটা বলছিলেন 1 নম্বর
Oh, my lord, বিপ্লব। I have received the clarification and as well as the.
What does it say?
First of all, so both the employee, the private respondent and the petitioner, both chose to
Kolkata.
One extension in their own place. Both chose for 1 year. So accordingly, we have and the clarification is given in this case. The why the respondent, private respondent, given the chance to extend his extension.
See,
given.
the private respondent has been retained in Kolkata. The petitioner's father is undergoing treatment of cancer here in Kolkata. He has been transferred from Murshidabad to Kolkata. Right? দেখি কি দিচ্ছে? There are 2 battalions in Kolkata. One is 145 and the other is 178.
That I'll say, because 145 is right now shifted to some other place.
145 shifted?
Shifted.
This said the cancellation has been done. But why done? Because they choose Dr. Abhijit Mukherjee choose for 1 year extension at his.
You have a copy. You have a copy. Give to him. Or read it so that both can share.
Yes, read it out. Read it out.
Read it.
Dr. Abhijit Mukherjee had completed 3 years prescribed tenure at Behrampur.
And
during his posting in 26, the officer received through such and such, wherein he requests Kolkata, Dibgaria, Kolkata, and Kollani. Or if his above request is not considered for posting, he may be granted 1 year extension at present place in Behrampur. Accordingly posted to 178 Kolkata during such and such. Thereafter, Saloni, who was posted in Anto, requested for DG's interview regarding 1 year extension on medical ground of her husband,
who suffered heart attack.
Subsequently appeared for research through video calls and considering because the DG granted 1 year extension to Saloni. Accordingly, she was posted, was granted 1 year extension. You applied for extension. In case Kolkata is not available, you applied for a 1 year extension in Behrampur.
No.
That
is wrong.
That is wrong. This is what
absolutely wrong.
He has
happens here. I never applied for transfer. I did not, because it is my lord annual transfer posting system, which happens after I chose my lord Kolkata because of my father.
No, thereafter, in case the place in Kolkata is not available, you mentioned that
I need to choose my lord 4 places anyways, A, B, C, D. So I had to do that.
And fifth place is in cases
not permitted anyways. So my lord, the rule, I have the rule, my lord.
Well, then did you apply? Because this has been mentioned that you also opted for 1 year extension in Behrampur.
No, I never applied for extension. No, can't be, because that would be beyond the rule.
Posting.
But that would be beyond the rule, because I have already posted over there for 3 years. So maximum I can be there for 3 years. I cannot be extended. And my lord, I myself, my lord, chose because my lord, was given with the option. I chose, that was considered, and as per the annual transfer policy, I was transferred. Then, my lord, comes the private respondent. Now she prays for extension
All right, one, just
after
wait.
5 years.
Just
So, my lord,
wait.
if that is the case, what I find from here, that is the case, she wants to be there because of the husband's problem, and if they
Yes.
consider that, so my lord, I also be maybe there, and she also may be there, because it is not the case that there cannot be more than one. If that is their case, that she can be permitted to stay here beyond the rule also, well, let her be stayed.
Not beyond, what is it?
Later.
Degi?
Where the fifth point, and see the fifth point.
Choice of posting. 1 year extension.
So nothing illegality.
Nothing illegality.
Nothing arbitrary in this order.
You have submitted a request wherein the postings place you have mentioned, or if my above request is not considered, 1 year extension may be granted in
No,
such
that
and
is,
such
that is
place.
completely, my lord, inconsequential, because that is what I need to do anyways. Because my lord, I because at the time of ATO, my tenure is already done for 3 years. So I need to, my lord, give the option. I gave. That was considered. I was transferred. Now I'm relieved from there. My lord, right now I'm in Kolkata. Now after 5 years, my lord, the private husband spent 5 years, not 3 years. 5 years is done. Now once again she asks for extension. She gets an extension. And that is affecting me. And my lord, lordship clearly sees the order of 23-24. Completely unreasonable one.
1 minute.
One says, my lord, 23 and 24. If it is not arbitrary, my lord, nothing else can be. Page number 23-24, lordship one says.
You please take further instruction. If the private respondent can get an extension here at Kolkata, then why can't the petitioner also be accommodated in Kolkata? Do you get it? He may have chosen or opted for 1 year extension, but that is the last resort.
Because
you accepted his application and permitted him to come back to Kolkata. Because there are 4 places. I can see the CH, BSF, SHQ, BSF, then Digberia and Kollani. 4 places. Can he not be accommodated in any one?
My lord, both the petitioner, both the private respondent and the petitioner chose to transfer.
No, nobody chose. This is in the usual course.
Transfer was made, but when private respondent
Please come.
for
Instruction has been forwarded
of her husband
by the respondent authorities. DIG within bracket personal
submission
dated 23rd of June 2026. It appears therefrom that the private respondent has been posted at Kolkata on a request made by her on the ground of her husband, who suffered heart attack and is undergoing treatment at Ranchi and Kolkata, as well as on the educational ground of her son, who is studying in class 10 in a school at Barasat, Kolkata. Stop. The private respondent has already spent 5 years at Kolkata. Stop paragraph. The respondents considered the request of the private respondent, but private respondent and cancelled the transfer of the petitioner at Kolkata and directed him to join his earlier place of posting at Murshidabad. Stop. No reason has been prescribed as to why the medical ground of the petitioner's father has not been considered by the authority. Stop. The petitioner's father is suffering from cancer and is undergoing treatment at the Tata Medical Center at Rajarhat.
Petitioner medical ground was considering the medical ground. Petitioner choose the extension of 2, 1 year extension 2. Considering his father's own medical ground, he chose the.
Father is in Kolkata and the petitioner will choose to stay in Murshidabad.
But he chose.
Certainly he didn't choose. He chose 5. Serial number 5 is the last option given by him. There are other 4. What about the 4? What about Kollani? Kollani, you didn't take any. There are 4 options. The petitioner disclosed 4 places of posting at Kolkata and nearby Kolkata. And his last option was an year extension at Berhampur. Stop. The authority is directed to consider posting the petitioner at any of his places, any of the choices for posting somewhere near Kolkata so that he may stay by his father at the time of his medical treatment. Stop. The age of the petitioner shall also be taken into consideration at the time of taking a decision with regard to the petitioner's prayer for transfer. এই অর্ডারটা আজকে করবেন, আজকেই আপলোড করবেন। বোঝা গেল? For further consideration on Thursday, 25th of June. ঠিক আছে?
By this time, because today I am supposed to go and join Berhampur.
You take steps. What is to be done? You can take leave or whatever.
Kindly grant and status quo so that at least I may not be compelled to go and join over there. Because it is completely unreasonable thing that they themselves know. The private respondent, even after
Whether
for the second
reasonable or
time,
unreasonable, let the
Lordship
court
will
take a
decide.
decision.
But the private respondent sub for the second time did not turn, will never turn up.
The matter is due to appear in the list day after tomorrow. Speak to your officers and Thursday, not at all. He is running short of time. No, he is already, today was his date of joining. The urgency is only for this reason. Otherwise, he'll be treated as absent. And proceeding will be initiated against him for not joining his transferred place of posting. No coercive action shall be taken against the petitioner for not joining his transferred place of posting till 25th of June.
Transferred, not transferred place. The earlier place. Because the transferred place is this one.
Retransferred place. Because your
cancellation of transfer.
আচ্ছা ওখানে লিখে দিন পরিষ্কার করে বেহরামপুর মুর্শিদাবাদ. So that no confusion is caused for not joining his place of posting at মুর্শিদাবাদ. বেহরামপুর মুর্শিদাবাদ. ঠিক আছে? আজকেই করে আজকেই সার্ভার করবেন.
Grateful, mother. It should come under the same heading of urgent motion.
Urgent motion item 1.
Grateful, man. So grateful.
Urgent motion item 1.
2 p.m. 2 p.m.
No.